Audio check, 1, 2, audio check.
All right, Ms. Ivy, are you ready? She is on mute. You made her, you made her be on mute. All right,
There
let's
you
go.
go.
Okay.
Okay, I have quite a few people on screen. Identify them. Okay,
We'll
I
do
know
that
who's
once we
gonna
go
be.
on. We'll do that once we go on the record.
Okay, thank you, sir.
Okay. And let's do go on the record.
On the
Good
record,
morning,
thank you,
Judge.
sir, at 9:00 a.m.
Okay. All right, we are on the record. Good morning. Today is May 26, 2026. The time is 9:00 a.m. The commission has set this time for an evidentiary hearing in the case captioned as in the matter of the application of Evergy Missouri West Incorporated, doing business as Evergy Missouri West, for approval of an amendment to Nucor Steel Sedalia LLC agreement. And Nucor is Nucor. It is the commission case number EO-2026-0129. My name is Ken Sire, and I am the regulatory law judge presiding over this hearing. The hearing is taking place in the Public Service Commission hearing room, room 310 of the Governor Office Building in Jefferson City, Missouri. Before we go any further, let's have counsel for the parties make their entries of appearance, beginning with Evergy.
Good morning. Jacqueline Whipple and Michael Robinson of Denton's US LLP. We are here with Roger Steiner of Evergy.
All right, and for Nucor?
Good morning, Judge. Mark Ellinger with Ellinger Bell and Joseph Briscar, with Stone, Mathis, Xenopoulos, and Brew on behalf of Nucor Sedalia Steel.
Thank you. For the staff?
Good morning, Judge. Paul Graham for the staff of the Missouri Public Service Commission. I'm here with Travis Pringle.
Thank you. And for the Office of the Public Counsel? Oh, sorry.
I forgot the most important part of my team is Ray Coonan. His maiden voyage here. He's sitting behind me, so he's out of sight and out of mind.
All right. And for the Office of Public Counsel?
John Kleiser on behalf of the Office of Public Counsel. My business address, Governor Office Building, Suite 650, 200 Madison Street, P.O. Box 2230, Jefferson City, Missouri, 65102. Thank you.
All right, thank you. For those in the hearing room, I ask that everyone to silence their cell phones and mobile devices. For those connected via WebEx, I ask that you mute your microphone when not speaking. The court reporter today is not present in the hearing room, but is instead participating via WebEx. Therefore, it is important that you speak into the microphone in the hearing room so that she can record all the proceedings. Before we get too far into this, I've got a couple of questions for the attorneys. First, for the attorneys, well, for the attorneys in general, I don't see, staff has not listed this as an exhibit. The document that was filed, the suggestions in opposition to non-unanimous stipulation and agreement. Is there anyone who would have an objection to that being admitted as an exhibit?
Your Honor, for clarification, are you asking for the...
I'm sorry, but I cannot see who's speaking, so if you're going to speak, you'll need to identify who you are first, please.
Thank you, Madam Court Reporter. John Kleiser, OPC. To clarify, Your Honor, are you asking for the admission of the entire suggestions in opposition, or are you asking for the admission of the attachment to the same?
All right. The attachment, refamiliarize myself. If you can refresh my memory as to what the attachment is.
Yes, Your Honor. This is Paul Graham speaking for the staff.
Do you have your,
Staff filed suggestions in opposition. Staff additionally filed proposed testimony responsive to the motion that the parties filed for an approval of a partial stipulation. So we tendered testimony and asked leave to have that admitted and, or to use it here at the hearing. That was the subject, I think, of the motion that you're talking about. So it's testimony in the form of a memorandum. It was mentioned as an exhibit to staff's suggestions in opposition to the partial stipulation, or non-unanimous stipulation.
Okay. What I'm referring to is actually just the pleading and not the attachment.
Well, Your Honor, staff wouldn't,
I'm sorry, speaking again.
Paul-
Each time you'll have to identify yourself because I can't always see the hearing room.
Paul Graham for the staff again. Ordinarily with staff, I thought that this was a pleading. You had ordered that anybody that wished to or needed to would respond by a certain deadline. I think you shortened it to 2 days, the rule deadline for responding to non-unanimous stipulations. And the objections or the suggestions in opposition which I filed or which the staff filed was in the nature of a pleading. And so we didn't tender it as an exhibit, but attached to it or as a part of that filing, we went ahead and tendered testimony in support of what we were saying. And that, of course, would be considered an exhibit, and we requested leave to file it. So I think your question goes to the testimony.
Okay.
So we want the pleading and the attachment.
I'm sorry, I cannot hear and I do not know who's speaking.
Paul Graham is still speaking. Paul Graham is still speaking. Do you have the EFS number? I thought
It is actually EFS, and for the sake of the court reporter, that
I'm
is.
sorry, again, I don't know who's speaking because I can't see.
This is,
It's not, go ahead.
this is Judge Sire. And Mr. Graham, we're referring to EFIS, that's EFIS, item number 45.
yes.
All right, let me take a look at that. All right, Mr. Kleiser, assuming we are talking about the suggestions, the pleading with all the attachments, do you have an objection to that?
John Kleiser, OPC, and you have put me in something of an awkward position because the OPC filed both an objection to the filed stipulation and an objection to the motion for leave to file testimony filed by Evergy. And to the extent that we filed that objection on the basis that there should not be additional rounds of testimony brought in this late in the case, I would think theoretically I would want to maintain that objection for all efforts to bring in additional testimony at this point in time, even though our current position is largely aligned with staff. So from a standpoint of do I object in the standard that it is against my party's interest for the staff to have that brought into the record? No. From the standpoint of am I objecting generally to the introduction of evidence brought this late into the hearing, which would include my written objection to Evergy's leave to file testimony in support of the stipulation, I would maintain that objection is same.
Okay,
Does the bench follow me?
a bit.
Fair enough.
All right, then let's, I'll take that off the table for now. All right, for Evergy's attorneys though, let me ask you this question. Staff has suggested that if the commission were to accept the non-unanimous stipulation and agreement, that there be some conditions attached to that. Which, if any, witness would be the proper person to ask questions of that?
Jackie Whipple for the company. That would be Brian File.
Okay, and Mr. Kleiser, same question. If we wanted to ask a witness from the Public Counsel's Office about their position on those conditions, who would that witness be?
John Kleiser for OPC. That answer would be Dr. Jeff Mark.
And that, for the sake of the court reporter, that is Geoff. Am I correct about that? Geoffmarke.
For the sake of Madam Court Reporter, do you need us to identify our party, or is just our name sufficient? That's John Kleiser.
Your name, sir. Thank you.
All right. Did the parties have any matters to take up before we get into opening statements? All right. All right. Would someone like to present an opening statement on behalf of Evergy?
Good morning. May it please the commission. My name is Jacqueline Whipple, and together with my colleague Michael Robinson of Denton's US LLP and Roger Steiner of Evergy, we have the privilege of appearing before you this morning on behalf of Evergy Missouri West, which we will also refer to as EMW. In this case, EMW and Nucor ask the commission to approve their May 18 non-unanimous stipulation and agreement, which would allow Nucor to participate in the company's demand response programs, including those under the Missouri Energy Investment Act, Missouri Energy Efficiency Investment Act, also known as MEA. Nucor's previous participation in EMW's MEA Business Demand Response Program, which we're also going to refer to as the BDR program, produced more than $2.5 million in avoided capacity costs at a benefit to all customers. Nucor's curtailment also produced SPP resource adequacy value. That value reduces the capacity that EMW must otherwise procure to meet SPP requirements, which also lowers costs for all customers. But staff and OPC either want to prevent Nucor from participating in EMW's MEA BDR program at all, or tack on unreasonable conditions that would treat Nucor differently than every other customer. So that customers can continue to benefit from Nucor's participation, the commission should approve the stipulation and agreement. In doing so, the commission should reject the conditions to the stipulation proposed by staff and OPC. Staff's and OPC's conditions unreasonably seek to treat one customer differently and impermissibly seek to create administrative and evidentiary burdens that are not supported by Missouri law. As EMW witness Brian File testifies in his May 18 testimony offered in support of the stipulation, in many respects, the stipulation addresses concerns raised by staff and OPC in their pre-filed testimony. Importantly, there is a safeguard built into the stipulation and agreement. If a financial analysis of Nucor's participation in the BDR program, again, like in its past performance, shows a net benefit to all customers, then the Commission's approval of the stipulation and its Nucor contract amendment automatically would extend for at least the term of that contract, which is currently through 2029. However, if that financial analysis shows a net cost to customers, then the conditional approval will expire at the conclusion of 2027. Of course, any participation by Nucor beyond 2027 would also be dependent on the Commission's future approval of the company's MIA programs. Staff's own Evaluation, Measurement, and Verification Evaluator, also known as EM and V Evaluator, will run this 2027 performance measurement using generally accepted baseline methodologies. All other provisions for service to Nucor under the Special Rate for Incremental Load Service tariff, or SIL tariff, will remain. That includes all pricing and rates, and every existing ratepayer protection remains intact. The stipulation confirms that Nucor is paid only for the kilowatts it actually reduces on the same MIA Cycle 4 BDR terms as every other participant. Under the stipulation, Nucor's contribution to EMW's BDR goals is capped at 30% of measured portfolio megawatts. If Nucor delivers more, EMW's earnings opportunity, or EO, is reduced to reflect 30% of the portfolio. Finally, any Nucor kilowatts counted towards EMW's 2027 BDR goals will not count toward the 65% threshold that vests EMW's earnings opportunity. The stipulation is supported by the company's pre-filed testimony and Mr. File's May 18 testimony offered in support of the stipulation, and it reduces the genuine issues in this case for the Commission's determination. As this Commission is well aware, and as EMW's witnesses Mr. File and J.P. Meitner testify, SPP has set increased minimum planning reserve margins of 36% margin for winter and 16% margin for summer, these effective starting summer of 2026. EMW, as the load responsible entity, must meet these new SPP requirements. Timely approval of this stipulation and the amendment permits the company to count Nucor's reduced load in the upcoming SPP accreditation seasons. The company's 2026 IRP annual update, filed on May 7, shows EMW satisfying its required capacity through 2028, during which time new load is expected to on-ramp. To meet its IRP goals, EMW plans to seek CCN approval for over 1.3 gigawatts of new generation by 2030. Demand response is important to EMW satisfying SPP's accreditation requirements. The megawatts SPP counts toward Evergy's resource adequacy obligation directly shape the resource mix and timing that the company's IRP model produces. If demand response is removed, the plan calls for more capacity sooner at a higher cost. Mr. Meitner and Mr. File testify about these aspects of SPP accreditation and the company's IRP. As I mentioned, Nucor takes service under the approved SIL tariff, Schedule SIL. Sheet 157 says that SIL service may not be eligible for participation in programs offered pursuant to MIA or for participation in programs related to demand response or off-peak discounts unless otherwise ordered by the Commission when approving a contract for service under this tariff. And so the tariff contemplates the Commission's approval of Nucor's participation via an amendment to the contract in connection with the stipulation. MIA provides that demand-side investments are valued the same by the Commission as supply-side investments, and so utilities may recover costs and earn on verified cost-effective savings. It also specifies that customers like Nucor who opt out of the Demand-Side Investment Mechanism, or DSIM, can participate in interruptible or curtailable programs. The Commission has already classified the company's BDR program as such a program in its March 11, 2020 order in EO 2019-0132. And as you are aware, the Commission approved EMW's MIA Cycle 4 portfolio, including the BDR program, by an order dated December 11, 2024, in case number EO 2023-0370, with the program running through 2027. EMW and Nucor are simply seeking approval for Nucor to participate in a program and budget already approved by this Commission. EMW's 3 witnesses have sponsored testimony and will be available to answer your questions. Brian Feil, Director of Demand Side Management and Energy Efficiency, will explain why the company needs demand response, why Nucor's participation helps every customer, and why staff's proposed alternatives to MIA are unworkable. He will also explain Nucor's event performance from 2021 through 2023, summarized in his confidential schedules BF5 and BF6. As mentioned, Mr. Feil also offers supporting testimony for the stipulation and agreement in this case. Linda Nunn, Senior Manager, Regulatory Affairs, testifies that the costs staff proposes to shoehorn into the SIL tariffs hold harmless calculation are not appropriately applied there, and why Nucor's participation yields system-wide benefits that reach every customer. Mr. Meitner, Director of Market Operations, will explain SPEP's resource adequacy rules and EMW's 2026 IRP annual update as related to the company's DR programs, and he will further explain how staff's and OPC's alternate DR pathways are non-viable. As far as the parties' prior filed list of issues, most of them have already been answered by the stipulation. The first issues A and A1, are resolved by the stipulation. As discussed, the Commission should approve the stipulation and its SIL contract amendment allowing Nucor to participate in DR programs offered by EMW, including the MIA BDR program, because the record establishes that it results in just and reasonable rates and is in the public interest. Similarly, due to the protections in the May 18 stipulation and the existing ratepayer protections in the SIL tariff itself, no additional conditions should be imposed. In addition to the stipulation, the SIL tariff contains 5 existing protections to ensure that customers are not and will not be harmed by Nucor's participation, which EMW's witnesses describe in detail. These include the hold harmless mechanism associated with the provision of electric service, the SIL-specific FAC subaccounts, the rate case revenue imputation EMW performs, the 25% 4-hour Nucor load deviation tracking, and the plan outage notice obligations. Together, these resolve issue A1 little a. Issues A2, A2 little a, and A2 little b ask if Nucor's participation in EMW's MIA BDR program would produce benefits to all customers, if those quantified benefits exceed quantified costs, and if the BDR program has a sufficient verification process for curtailments. The answer to all of those questions is yes. In approving the MIA Cycle 4 portfolio, this Commission expressly found that the Cycle 4 stipulation meets the aforementioned MIA standards. As Mr. Meitner and Mr. Feil testify, SPP verifies and credits Nucor's tested reductions against Evergy's resource adequacy obligation. Every customer shares in that RA reduction. Nucor's prior verified peak demand reductions resulted in a benefit cost ratio of twice more benefits than costs. As Mr. File testifies, those figures used commission-approved Cycle 3 avoided capacity costs and third-party measured and verified reductions, and they exclude transmission and distribution avoided costs. This in turn means the real benefit to cost ratio likely runs higher. As to the verification part, ADM and Associates ran the 2021 through 2022 baseline methodology as third-party evaluation consultant. Staff's own EM and V consultant, Evergreen Economics, oversaw that work. Neither of these third parties flagged Nucor's baseline or any methodological concern. Participants will be paid only for measured demand reduction after each event, and SPP separately validates the megawatts that count toward Evergy's resource adequacy. Going forward, the stipulation puts the 2027 performance measurement, that financial analysis mentioned in the stipulation, in the hands of staff's EM and V evaluator based on generally accepted methodologies. Issue A2c asks if there are other DR participation pathways available to Nucor and what detriments or benefits are there to those. Staff and OPC have identified so-called alternative pathways, but none of them are workable, as Mr. File and Mr. Meitner testify, and as this demonstrative chart demonstrates. As Mr. File and Meitner testify in SPP, only Evergy as the load responsible entity earns resource adequacy value through its programs. Schedule MBDR is a supplement to BDR by its own terms, and the resource adequacy value that MBDR could deliver is already captured through BDR participation. Aggregators of retail customers, or ARCs, or direct SPP wholesale participation do not give Evergy resource adequacy credit. Issue B asks whether existing hold harmless and cost tracking protections are sufficient to protect non-SIL customers from any cost shift attributable to Nucor's service if Nucor participates in EMW DR programs. As we have discussed, the answer is yes. Again, the stipulation contains the conditional approval protection. Further, as Ms. Nunn testifies, at each general rate case, EMW imputes revenue to cover any shortfall between Nucor's rate revenues and the incremental cost to serve. Any deficiency falls on shareholders, not on other customers. Moreover, SIL-specific FAC subaccounts track the Nucor PPA, market, and transmission costs and revenues. That tracking has produced only minor adjustments to date. Staff and OPC would run MIA program costs through the SIL tariff's hold harmless calculation, claiming that those MIA program costs are a cost of serving Nucor, and that excluding them from the hold harmless calculation in the tariff would cost non-Nucor ratepayers unfairly. But the Commission's Cycle 3 order in EO 2019-0132 already directs that DSIM opt-out customers who participate in demand response are compensated, with the costs flowing through the DSIM, not through any electric service specific hold harmless provision. Ms. Nunn will explain why mixing up these concepts creates an absurd result where EMW shareholders bear all of the costs while every other customer pockets the benefits. Issue C asks whether the Commission's approval of Nucor's participation in the MIA BDR program should impact EMW's ability to receive an earnings opportunity for verified savings produced by Nucor's participation. The answer is no. The stipulation carves out Nucor's 2027 kilowatts from the 65% vesting threshold for EMW's earnings opportunity, and EMW is on track to clear that threshold without Nucor. The stipulation also caps Nucor's contribution at 30% of the portfolio for EO purposes. Otherwise, based on the stipulation, EMW should receive the standard earnings opportunity for Nucor's third-party verified savings on the same pay-for-performance terms that govern other MIA BDR participants. The Commission set the Cycle 4 EO structure when it approved the Cycle 4 stipulation, and nothing in that order or MIA carved Nucor out of it. Removing EMW's earnings opportunity would unfairly penalize EMW for delivering the resource that MIA is designed to incentivize. EMW needs demand response to meet SPP's new resource adequacy requirements, as further confirmed by the company's latest 2026 IRP annual update. Nucor is a proven resource, providing measurable benefits to all customers. Even so, the terms of the stipulation, along with the SIL tariff's existing protections, shield ratepayers from any shortfall. Accordingly, the Commission should approve the stipulation and its SIL contract amendment because the record establishes it is in the public interest and results in just and reasonable rates. The Commission should reject conditions to the stipulation proposed by staff and OPC, which unreasonably seek to treat Nucor differently than every other EMW customer or attempt to create burdens beyond MIA's statutory requirements. Thank you.
All right, this is Judge Sire. Are there any questions from the commissioners? All right, thank you. All right, opening statement on behalf of Nucor Steel.
Good morning, Your Honor. Good morning, Commissioners. My name is Joseph Briscar of the law firm Stone, Mathias, Annapolis & Brew, and I'm here with Mark Ellinger of the law firm Ellinger Bell, and along with my colleague Michael Lavanga, we represent Nucor Steel Sedalia in this case. Nucor Steel Sedalia is a steel mill that uses an electric arc furnace to melt and recycle scrap steel into new steel products. The Sedalia mill is one of the newest steel mills in the United States since it opened in 2020. Nucor is proud of its partnership with the state of Missouri and looks forward to being part of the Sedalia community for many years. Before Nucor started up in Missouri, this commission approved a special contract for the Sedalia mill. The commission also approved the SIL tariff to comport with the special contract. Both the contract and the SIL tariff have been in effect since 2020. Nucor and Evergy now have negotiated an amendment to the special contract to allow Nucor to participate in Evergy's demand response programs. The amendment was filed with this commission, and that in this case was initiated. Today, we respectfully ask that the commission approve the non-unanimous stipulation agreement between Evergy and Nucor to modify Nucor's contract with Evergy to allow Nucor to conditionally participate in Evergy's business demand response programs and just demand response programs in general. The stipulation and agreement is in the public interest, provides ratepayer protections, and allows Nucor to participate in valuable demand response programs at a time when electric markets across the country are experiencing dramatic load growth capacity constraints, and higher energy prices, demand response is becoming an increasingly important tool to help lower energy costs and ensure system reliability. While the evidence in this case shows that Nucor's participation would provide benefits to Evergy's system, both staff and the Office of Public Counsel witnesses question the validity of those benefits. The stipulation and agreement addresses those concerns. Specifically, it provides that Nucor's participation in Evergy's Business Demand Response Program will be conditional for 2027. Evergy will then conduct a financial analysis of Nucor's participation. If the benefits to customers outweigh the costs, Nucor can continue to participate. If the costs to consumers outweigh the benefits, Nucor will not be allowed to participate beyond 2027. In addition, the stipulation and agreement provides reasonable conditions on Evergy's earnings opportunities from Nucor's participation in the Business Demand Response Program, intended to address the concerns raised by staff and OPC. In short, through the stipulation and agreement, Evergy and Nucor are requesting that the Commission approve a trial period to show that Nucor's participation in Evergy's Demand Response Program can deliver value to all customers. Thank you for your consideration, and respectfully urge that you approve the contract amendment and the non-unanimous stipulation agreement.
Thank you. Are there any questions from the commissioners?
Judge Sire, I have just one.
Commissioner Mitchell.
Thank you. I notice on the list of witnesses that there's not a witness from Nucor other than in the opening statement. So I guess my question is, we heard in Evergy's opening statement that the benefit cost ratio was around 2, and that in the conditional participation section of the agreement, that if that benefit cost ratio exceeds 1, then the program would be allowed to continue on in beyond 2027. And in the agreement, I didn't pick up if there were additional verifications after 2027 to allow that participation to continue, or will it only be one verification, or will it go into the standard verification process at that point?
My understanding is specific to the settlement agreement in this case and Nucor's participation, the financial analysis is only for 2027, for the 2027 period. And if the benefits and costs show that Nucor's participation, or that the benefits do not exceed the cost in 2027, then Nucor will not be allowed to participate. Thereafter, my understanding is that it would just be part of the normal measurement and verification as part of the MEEIA programs.
Part of the EM&V
That's right, yes.
assessment. Okay. Thank you. That helps me.
Of course. Anything further?
No, thank you.
All right. Thank you.
All right, this is Judge Sire. Staff, would you like to present an opening statement?
Ray Canine, here with Paul Graham and Travis Pingle on behalf of staff. May it please the commission. We have a problem. This commission's staff wants to support approval of the stipulation between Evergy and Nucor, but it must be in compliance with MIA and the hold harmless provisions of the Special Incremental Load Agreement, or SIL. Through the passing of MIA in 2009, the legislator made it clear its intent to value demand-side curtailment. Demand reduction means more capacity, more secure capacity, reduced purchase costs, and benefits to all. MIA was designed to be funded by
Sir, could you slow down
ratepayers.
just a little bit, please?
Absolutely.
MIA was designed, please continue from there. MIA was designed,
MIA was designed to be funded by ratepayers, but only if the benefits to the customers outweigh the costs. Commission staff wholeheartedly support programs that reduce energy demand and bring benefits to all ratepayers. Staff witness Jordan Hull will provide testimony of the various demand-side programs that achieve these goals without the need for additional costs to ratepayers. The stipulation reached between Evergy and Nucor failed to meet the stringent requirements of MIA and failed to properly adhere to the hold harmless provisions of the SIL. Evergy and Nucor bear the burden of proof because they are the signatories to this stipulation. MIA requires cost-effective and verifiable energy demand savings benefits to all members of the customer class, regardless of participation, and the fair apportionment of the cost and benefits to each customer class. Unfortunately, numerous problems exist with the stipulation reached between Evergy and Nucor. The first problem is verification of load reduction and the resulting benefits to all customers. Evergy's method of determining a baseline load for Nucor is unpractical and unreliable and taints all the data offered as proof. Nucor's load is too volatile and unpredictable for the approach proposed by Evergy. Evergy witnesses rely on stale data from Nucor's problematic participation in the company's third cycle of MIA. That data is irrelevant here. The deemed or assumed statistics do not properly solve the problems. Evergy provides no work papers or documentation to support its assumptions on the benefits or measuring curtailment. Without the ability to properly verify the baseline, there can be no proper way to verify benefits. Therefore, this stipulation cannot support measurable and verifiable energy savings in accordance with MIA. However, the problems do not end there. MIA requires the Commission fairly apportion the cost and benefits of demand-side programs to each customer class. This stipulation does not do that. The stipulation has everyone but Evergy and Nucor paying the costs. Nucor's SIL tariff clearly states that the SIL contract shall collect at least the incremental costs incurred by the company to serve the customer, explicitly stating that all the charges for service under this rate schedule shall be limited to the charges contained in the contract between the company and the customer. There are no other parties to this agreement. The SIL tariff states that non-participating customers, that is everyone else, shall be held harmless from any deficit in revenues from serving Nucor, and that the company will make adjustments to cover the cost shortfalls so that non-schedule SIL customers are held harmless. There lies the root of another problem. The cost associated with Nucor's participation in MIA, such as administrative costs, earnings opportunities, and incentives to Nucor, are being dumped on the other ratepayers. These are some of the cost of serving Nucor, and the SIL tariff explicitly forbids them from being paid by anyone else. Staff witness Jordan Hull provides testimony that Nucor can participate in demand-side programs outside of MIA, programs that are not funded by ratepayers, such as the Regional Demand Response Program through the Southwest Power Pool, or SPP. But as I stated when I started, staff of this commission supports approval of the stipulation between Evergy and Nucor so long as it is amended to be in compliance with MIA and the hold harmless provisions of the SIL, not before. Evergy offers problems disguised as solutions. An expiration of the program after it's been proven to cost more than it's worth doesn't make ratepayers whole. Neither will limitations on the earnings opportunity or how Evergy gets its accreditation. The stipulation doesn't offer a path to make ratepayers whole after the fact. As I previously stated, Nucor's load is volatile and unpredictable. The Commission can mitigate the risk by establishing a firm cap or firm service level for Nucor.
Firm what level?
Cap or firm service level.
Service level. Thank you. Go ahead.
You're very welcome. Simply identifying whether Nucor kept its load below the cap during a qualifying event. Exhibits 103 and 4 and Exhibit 104 further offer guidance on this. The firm cap must be set at a level sufficient to produce a benefit over cost. Once established, Evergy must demonstrate that the actual demand curtailment produces verified credit resource adequacy with SPP in order to show a benefit. This includes demonstrating Nucor's ability to curtail during weak winter peak periods and the accounting for Nucor's future peak demand. The benefit must then be compared to all the cost of serving Nucor through MIA, as the SIL tariff requires. This includes administrative and incentive costs. there must be an all-cost net benefit calculation. Anything short of this would allow Evergy to punt the unaccounted cost to other ratepayers. Lastly, the commission must include a clawback provision that ensures Evergy credits or refunds non-participating customers in accordance with the SIL to hold ratepayers harmless. Evergy bears the burden of showing Nucor's participation in MIA would be cost-effective, beneficial to all, and adherence with the hold harmless provisions. Evergy fails to demonstrate that this stipulation does that. Staff offers solutions that adheres to MIA and the hold harmless provisions. Establish a firm cap, require compliance with SPP for credit and benefit verification, and insert clawback mechanism to hold ratepayers harmless. Staff witness Mark Kiesling provides testimony.
Again, sir, could you slow down just a little bit?
Absolutely. Staff witness Mark Kiesling provides testimony on benefits, costs, incentives, and avoided capacity. Staff witness Justin Tevy provides testimony on the baseline volatility, load curtailment, capacity costs, and the hold harmless provisions of the SIL, and the conditions the commission should order for Nucor to participate in MIA. Staff witness Jordan Hull provides on alternative demand-side programs, SPP compliance, and staff's recommended amendment for Nucor's SIL agreement permitting Nucor to participate in demand response outside of MIA. Evergy stands to earn up to $200,000, and Nucor over $1 million. All that at the expense of ratepayers outside of its class, all without proof of any benefit to those same people paying the cost. Evergy has failed to meet its burden of proof. Staff of the commission asks that the commission approve the amendment to Schedule SIL, allowing Nucor to participate in BDR programs outside MIA, or in the alternative, permit Nucor to participate in MIA, subject to the conditions offered by staff witness Justin Tevy. Thank you.
Are there any questions from the commissioners? All right, thank you. Mr. Kleiser.
Good morning. You hear me? Super.
Yes.
Good morning.
Yes, sir.
John Kleiser on behalf of the Missouri Office of the Public Counsel. I'd like to start this morning by taking just a moment to sort of reorient this case a little bit because predictably, I think, after listening to 3 other openings, there's been a lot of focus placed on the benefits that come with demand response programs. And I want to make sure it's very clear to everybody that this case is not about whether or not demand response programs are good or bad, nor is this case about whether Nucor should be participating in demand response programs. This case really comes down to a singular issue, which is, should Nucor be participating in MIA demand response programs? And by MIA, I mean Missouri Energy Efficiency Investment Act. And the reason I say that's the only issue is because there are viable alternatives for Evergy and for Nucor specifically to participate in demand response programs. Now, I have committed what I consider sort of the cardinal sin of presentations. I've just thrown a whole wall of text up there, and instead of trying to read it out loud, I'm just going to give you a second to take a gander at that. Feel free to read it for just a second. This testimony, I don't know if I've gone too fast here. This testimony is taken from Staff Hull's rebuttal, and it outlines at least 2 or 3, however you want to count, viable alternatives for Nucor to participate in demand response programs. They can either do that through SPP-offered options directly or through what are called aggregators of retail customers, or ARCs. And effectively, the OPC's position is that instead of using MIA, we should be using these alternatives. And the rest of this presentation is pretty much just going to be me going through and explaining the differences between these two, the benefits and the detriments, and explaining why we believe the alternatives are superior. So, I'm going to start with resource adequacy, because that was a topic that was touched on very heavily by Evergy. Evergy already identified the need for resource adequacy, meeting resource adequacy goals, and how business demand response programs can achieve that. However, Evergy came up here and told you that the alternatives being offered by staff and OPC would not meet those resource adequacy requirements. And I'm afraid to say that is a flat false statement. If you look at the actual testimony offered by Evergy's own witness, per their discussions with SPP, Evergy, as a load responsible energy entity, can utilize Evergy market registered DR programs, and those are the same programs that were referenced by Jordan Hull just a couple slides ago, in their resource adequacy workbooks. They can use these alternatives to meet resource adequacy. That is Evergy's own statement. Now, Mr. Meitner, and I hope I pronounced that correctly, goes on to state that there are no current programs for these alternatives, and that without being run through a program with the LRE, Evergy, they wouldn't be able to count. Well, that's true, but it's also a very easy problem to fix. Just create the program. All you need to do is register these participants, either the ARCs or Nucor if it wishes to participate individually, with Evergy, with the SPP, and you will be able to utilize them for resource adequacy purposes. That's, again, per Evergy's own statement. So as we go to back to that chart, that first line, they're both checked. Both MIA and the SPP or ARCs will provide resource adequacy moving forward. And I want to point out that that's only for 2027. It is important to note that we've actually already missed the deadline for inclusion of any of these programs for the 2026 period. So this is actually starting as of 2027. But the point here is that both of these options will meet the resource adequacy goal. Next up is competition. Now, why do I bring up competition? Well, if you were to ask me, the goal of this commission, writ large, is effectively to serve as a proxy for the market. And when I say serve for a proxy for the market, your goal, I believe, should be, whenever possible, to emulate or at least promote competition. And you can see here a quote from OPC witness Dr. Mark, who states as much. And he actually quotes the known and famous economist Alfred Kahn, who states, "Whenever competition is feasible, it is, for all its imperfections, superior to regulation as a means of serving the public interest." So this commission should want to promote competition. And by the way, it's not just Dr. Mark. You have here a quote taken from a joint letter from the U.S. Department of Justice and the Federal Trade Commission of the Supreme Court of Tennessee, which again extols the virtue of competition. This is what we should be promoting. This should be the central goal of the commission, is to promote and improve competition. And if that wasn't enough, take a look at your own mission statement, where you twice refer to competition being something that you wish to promote within this state as part of your mission as a commission. So why am I harping so much on competition? Well, because what we have in front of us is an actual, genuine chance to actually promote competition in this state. ARCs, which again, aggregators of retail choice, I might be wrong on that, represent true market-based alternatives that allow for competition in this state on the demand side management front. This is an opportunity for you to fulfill your own mission statement, to fulfill the goal of this commission, and to allow for competition in this state. If, however, you allow Evergy to run these demand response programs through MIA, you're going to be killing competition. Because what third-party competitor would want to compete with a utility who has the backing of captive ratepayer funding to run their programs? No one would. So if you truly want to promote competition in the state, you need to allow for ARCs to participate. And in this case, that means saying no to the application. Let's next talk about cost savings. So, using one of the alternatives we've described, either through the SPP direct participation or through ARCs, we are going to save ratepayers money. First, we're going to have to avoid paying Nucor out of the MIA budget. You already heard staff counsel explain that that cost is roughly $1 million. We also do not need to include them in our EM&V. Now, I want to point out that the existing EM&V contract was set up on the assumption that Nucor was not a participant. It's the OPC's position that if you include Nucor as a participant moving forward, we'll need to renegotiate that EM&V contract, which could theoretically lead to increased costs. We would like to avoid doing that, which is why we believe that not including them and keeping the existing EM&V contract is in the customer's best interest. Finally, we can avoid having to pay an earnings opportunity, i.e. profit, to Evergy to account for Nucor's participation. So, based on those, we again see we have cost savings using our alternatives. But I want to come back to this for just a second, because it's that last point that really you need to understand that's what's driving this entire case. The reason that we're here right now is pretty much down exclusively to the fact that Evergy feels entitled to the earnings opportunity that it would earn through MIA. And the only way it earns that earning opportunity in this case is if Nucor participates through MIA. If it doesn't, if it participates either directly in the SPP or through an ARC, Evergy won't have that earnings opportunity. And so that really is the main question, in my opinion. Is this commission going to allow Evergy to operate as an expensive and unnecessary middleman, jacking up costs by running the program through MIA, or can we use one of these alternatives, which already exists, and reduce costs accordingly? I think the option or the answer is exceptionally clear. I have two more things on my little grid. The first is the violation of the hold harmless provision. This has obviously been sort of touched on a bit, so I'm going to give you a very high level, very simplified explanation. Evergy's SIL tariff says that non-participating customers shall be held harmless from any deficit in revenues provided by any customer served under this tariff. By participating in the MIA program, Nucor will get a discounted bill while other ratepayers do not. A discounted bill results in a deficit in revenues, hence the violation. I'm going to be honest, that is a probably gross oversimplification, but again, I wanted to present a simplified version of this. And also, while we've noted, Nucor will not be paying any part of the MIA program costs, that DSIM charge. And I do want to take just a moment to respond to something that was said earlier. Evergy in its opening made a great deal of the fact that staff in the OPC seem to be wanting to treat Nucor differently. And I want to stress to you, Nucor is treated differently because Nucor fought tooth and nail to get its own tariffed rates. It has the SIL tariff. It is the only one on the SIL tariff. So for them to come in and fight hard to be treated differently and then complain because they're being treated differently seems hypocritical in my opinion. But I digress. Getting back to this grid, you can see participating in MIA will potentially result in tariff violations because of the hold harmless provision. Whereas if they participate through SPP or ARCs, we can avoid that. The last issue is the accuracy problem. And I'm going to be honest, this is a complex issue. It's addressed at length in staff testimony. I don't want to get too deep into the weeds. So instead, I'm just going to give you a brief excerpt from staff witness Tevi, who explains that from staff's opinion, there are problems determining the accuracy of Nucor's load, and that will have knock-on effects in properly measuring the amount of demand savings that are generated. Now, I want to again stress to you, your staff doesn't have a dog in this fight. By which I mean, if it tells you it has accuracy problems, it's not trying to, it doesn't have a profit motive. Evergy, on the other hand, quite clearly has a profit motive. So I ask you to keep that into consideration and please give due diligence to the fact that your staff is saying they believe there is a legitimate problem to accurately measuring the load of this customer, and that will have an effect on MIA. So, again, we add that last check mark. And as you can see from this graph, there are substantially better alternatives in place from using Evergy's existing MIA. I want to summarize here really quick. As I already said, there are better alternatives. Nucor's participation will most likely violate the hold harmless provision, and there are fundamental problems to applying the MIA framework to Nucor accurately. Really quick, just to look forward on a couple of things, this is something I just want the commission to sort of be aware of. SPP has submitted tariff revisions for demand response programs to FERC, and those rules are under review. So this is something that is actively being worked on by the FERC. Also, I want to, again, there was discussion earlier, Evergy has massive load additions coming on, most of those coming on from hyperscalers. And frankly, those are going to completely dwarf the impact that Nucor has. So what we're doing here, while important, is largely going to be rendered almost irrelevant if the amount of load that we're expecting to come on actually does come on. And finally, I also just want to reiterate that we have in fact missed the deadline for 2026. I want to make sure that that's very clear to this commission. All right, so that brings me to the very end. And again, I'll wrap up on this last one. We have an opportunity here to do demand response, but to do demand response in a way that promotes competition, that saves customers money, that avoids having to muck about or potentially violate the MIA tariff, and can avoid the accuracy problems that are exhibit because, as staff explains in their testimony, SPP has a more rigorous verification process. And the only thing it will cost is for Evergy to not get its earnings opportunity. So the question before this commission really is literally just this. Do you want Evergy to act as an unnecessary and expensive middleman or not? And with that, I'll ask if there's any questions.
All right. Thank you, Mr. Klauser. Evergy, would you like to call your first witness?
Yes, this is Roger Steiner, and we call J.P. Meitner.
Before we get into Mr. Meitner's testimony, was that the list, the order of the list of witnesses?
This is Roger Steiner. It was not. Ms. Nunn has a travel issue, and the parties.
I'm sorry. Since I can't see who's talking, even though it might be repeat and repeat, please identify yourself.
Roger Steiner, Evergy. Ms. Nunn was scheduled to be first, but the parties agreed she had travel issues and she could be taken out of order.
Okay. Do we know when you expect her to testify?
Probably around noon, or she was traveling, so,
Okay.
But she'll be here today.
All right, thank you. All right, Mr. Meitner, would you raise your right hand, please? Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth? All right, thank you.
This is Roger Steiner again. Please state your name for the record.
J.P. Meitner.
Mr. Meitner, where do you work and what is your position?
I work in Topeka, Kansas. My position is Director of Market Operations.
And you're employed by Evergy, is that correct?
That's correct.
And did you cause to be filed in this case surrebuttal testimony, which has been previously marked as Exhibit 5?
I did.
Do you have any changes or corrections to that testimony?
No.
Your Honor, at this time I would offer Exhibit 5 into the record and tender the witness for cross-examination.
Right. Are there any objections to the admission of Exhibit 5?
None from staff. Paul Graham speaking.
All right. Exhibit 5 is admitted. All right. For Nucor?
Joseph Briscar for Nucor. We do not have any questions. Thank you.
Okay. Mr. Graham?
Yes, this is Paul Graham speaking. Good morning, Mr. Meitner.
Good morning.
I'm sure you were here and you heard the opening statement made by Ms. Whipple.
I did.
Okay. And you've heard the opening statement also made by Mr. Kleiser.
Yes.
And both of them raised the issue that that staff and OPC appear to be asking the commission to treat Nucor differently than other participants. You heard those statements, is that right?
I'm sorry, can you repeat the question?
You heard the opening statements to the effect that staff and OPC, the Office of Public Counsel, appear to be asking the commission unreasonably to treat Nucor differently than other customers. You heard that, did you not?
Yes, I heard the opening statements.
Okay. Now, Nucor, in fact, is a steel smelting company, is that right?
I believe that was what was said in the opening statements.
Do you know that to be the case?
I believe that to be the case.
And in your investigations in this matter, acting on behalf of Evergy, you know that to be the case, that Nucor is a steel smelting company.
That's correct.
And you are aware that one of the main threshold gateway issues in this case is the problem of setting a baseline for all calculations that are going to be made with respect to detriments or burdens that this program, this proposed program, may cause.
I'm going to object that that asks for a legal conclusion.
I'm sorry, who's objecting, please? I cannot see.
This is Roger Steiner, Evergy. I'm going to object that question asks for a legal conclusion that hasn't been established, but this witness isn't prepared to answer.
Mr. Graham?
Well, with respect to issues, we have, whether it's an issue or not, we have listened to several opening statements here where no such objection was made, as the counsel for Evergy and Nucor both laid out for the commission the issues that would be addressed here. The questions that must be answered here are not entirely legal. They are factual. In fact, in order to get to the legal issue, you have to go through the gateway of the factual issue, and that's what I'm asking this witness. A baseline is not a legal question. A baseline for the calculation of the effects of a program is at the threshold, and in fact at every step all the way through, a factual question followed by factual and factual questions.
But
I'll overrule the objection.
All right. Now, you are aware, I assume, sir, or tell me if you are aware, that the load, the electrical or power load that Nucor presents at any moment or over a span of any particular time in its smelting process is very volatile. It jumps up and down.
I'm not familiar with the volatility of their load. I could speak to the requirements at SPP around proof of the validity of a load for demand response
All right.
via resource adequacy.
Okay. But with respect to this particular customer and its volatile load, you're not prepared to testify.
I'm not prepared to speak to Nucor's volatility or lack thereof in their
Okay.
load.
And you're not prepared to testify, therefore, concerning why Nucor might be cut out of the pack and looked at a little bit differently than any other customer on account of baseline problems.
objected, asked and answered. He said he's not.
I'm sorry, again. Who is
This is
speaking, please?
Roger Steiner with the company Evergy. Asked and answered. This witness said he is not prepared to answer questions about Nucor's load characteristics.
Do you know,
I'll sustain the objection.
okay, do you know of any other witness who will be testifying in these proceedings that, on behalf of Evergy, that would be prepared to answer those questions about Nucor's particular challenges or the challenges that it presents in establishing a baseline for calculating whether, in fact, Nucor would be bringing anything positive to the table? Do you know of any other witnesses that Evergy's got?
I believe the best witness to speak to the measurement and verification of Nucor load would be witness file.
All right, that's all the questions staff has.
All right, Mr. Kleiser, do you have questions?
No, Your Honor, thank you.
All right, thank you. Do the commissioners have any questions? Chair Hahn.
Morning, Mr. Meitner.
Good morning.
It's my understanding that staff and OPC's primary contention is that they prefer Evergy and Nucor to use the SPP programs or ARC programs. In your rebuttal testimony, you discuss why perhaps participation in the SPP programs don't provide all the benefits. Can you please explain what that means and how SPP operates those programs, please?
Sure. So in my rebuttal testimony, I was really speaking to the concept from SPP's perspective about how those programs would work from a resource adequacy perspective. What I pointed out was that based on Evergy's tariffs, that the only option to participate is the MIA BDR. Just pointing out some of the challenges with the other programs, starting with ARC as an example, is that that aggregator of load would still need to be a vendor of Evergy Missouri West, meaning they would sell that demand response aggregation to the Missouri West portfolio that would then be included in the resource adequacy workbook. Otherwise, if it is not in Evergy's Missouri West workbook, it cannot be claimed towards resource adequacy regardless of where the customers reside, a service territory, anything else. So there's still that cost because that aggregator is looking to be paid for that aggregation of demand response. The the SPP demand response programs, the dispatchable and the block, again, can qualify for resource adequacy, but again, that is not in Evergy's tariff. The MBDR, where it's suggested that that would reside, is really a supplement to the MIA program, which is where the where the resource adequacy resides. And the MBDR program is really designed to participate in the energy and ancillary markets and not for resource adequacy.
So I want to make sure that I fully understand this. If Nucor were to participate in one of SPP's tariffs or through a third-party aggregator that would then sell at SPP or is registered with SPP, Evergy Missouri West would not get any capacity accreditation for Nucor as a resource.
Based on where it is today and based on assuming that the ARC would not be a vendor of Evergy Missouri West, there would be no resource adequacy benefit to the Evergy Missouri West customer from those programs.
Are there any aggregators within Evergy Missouri West?
I don't know for sure if there are aggregators. I assume there are, but I cannot say that for certain.
Thank you.
Are there any other questions from the commissioners?
One more question.
Oh, Chair Hahn.
Sorry. The commission had set a standard of 100 for larger customers being able to participate within a third-party aggregator. I can't remember the exact megawatt threshold. Would Nucor qualify under that megawatt threshold to be an eligible participant of a third-party aggregator?
I don't know that answer. I apologize. I'm sure someone with Evergy does.
Okay, thank you.
All right, thank you, Chair Hahn. I do have a question myself. Are demand response calls under the BDR, the Business Demand Response Program, made during the summer?
Yes.
I'm sorry, oh, excuse me. Okay, I got it. Thank you.
Yes, this is Judge Sire.
Yes.
And are business demand response calls under the BDR program made during the winter?
I believe witness file would be able to speak more to the specific mechanics of those
Okay.
call opportunities.
Okay. All right.
Judge, if we could take a break at some point in the future, please?
Yes, after this witness.
Thank you, sir.
Does Nucor have any recross?
Joseph Briscar for Nucor? No, thank you.
Judge, if I may, I had a question or two as well.
Oh, I'm sorry, Commissioner Mitchell.
Yes, thank you for your clarifications. I am curious, in the alternative participation pathways that have been suggested, I'm assuming that there is some cost involved in participation, either directly with Southwest Power Pool or if the DR participation came through an aggregator. And I'm curious how those costs are then recovered, either by the aggregator or by Southwest Power Pool, and then how they then translate to cost to the ratepayers.
Yeah, that's a good question. So, as I said earlier, first starting with the ARC program, that aggregator would have an expectation of compensation for the program when they sold that to someone that was looking for accredited capacity. I think it's important to remember that in SPP there is not a capacity market like maybe you would think of in MISO or another RTO. And so a RTO with a capacity market, there's a much smoother avenue for that capacity to receive payment. In SPP, because it's a capacity obligation but not a capacity market, there would then need to be a bilateral transaction between the parties for that accredited capacity to then hit, in this case, the Evergy Missouri West Resource Adequacy Workbook.
Okay. And I think I also heard in OPC's opening that for both SPP, well, maybe just for SPP is what I heard, that FERC is working on the tariff language that would address participation directly with SPP. So fair to say that those programs aren't, as we speak today, those programs aren't available, or they're in some state of evolution at this point.
Are you speaking directly to SPP registered demand response program or ARCs?
Yes.
Asking if those are available today? No, those would be available today. I think the point, well, I should think, but the point made earlier, I think, is around that there are a lot of changes going on at SPP and other RTOs for that matter around everything resource adequacy. It's a big topic at a lot of RTOs, and I think that it was just pointing out that there's continual conversation around the evolution of resource adequacy at SPP.
Okay, thank you. I'm going to ask you to generalize just a little bit, but given the RTOs, the impacts of Winter Storm Fern on the RTOs, how do you think the demand response programs performed in terms of their reliability and effectiveness?
Specifically for SPP, I believe that they've made a lot of progress in the validation, verification of demand response programs, really since Winter Storm Uri, where SPP realized post-event that they didn't have a lot of visibility into these programs. And so I'd say most notably, again, where a lot of my testimony was focused was on resource adequacy treatment of this program, and SPP has taken great strides in the verification of demand response programs to ensure that those programs bring the benefit that they're being accredited for in the workbook. So, you know, when we think about measurement and verification for resource adequacy purposes, Evergy Missouri West measures it the exact same way that SPP does, in the fact of determining whether the program is meeting the potential that it said it brings. And once that's confirmed by SPP prior to that peak season, that value is brought to the customer through the workbook in a reduction of demand response that would need to come from somewhere else, because those megawatts are now showing up in that workbook for that peak season. And that's in every peak season, there's a requirement to continue to provide that documentation and whatever records that SPP requires to validate that that program should indeed fall within the workbook.
Thank you, Mr. Meitner. That helps me understand. Appreciate your testimony.
Thank you, Commissioner Mitchell. And Chair Hahn has another question.
Yeah, I'm going to follow Commissioner Mitchell's questions. SPP currently has a filing pending at FERC to expand their demand response programs. If that, which will be litigated, if that is approved, the resources that are then registered with SPP, would they count toward the resource adequacy calculation of Evergy Missouri West at SPP?
Conceptually, they could, and they could today. The point that was made earlier is that the only tariff program that Evergy has available to participate in resource adequacy is MIA.
Okay. Thank you.
All right. At this point, let's take a break, and then we will reconvene, let's say 10:35. I'm sorry. We will, right now. Okay. I'm sorry. We are not going to break at this time. Mr. Briscar, do you have further recross, or any recross?
No recross.
All right. Mr. Graham?
This is Paul Graham. Yes, picking up on the questions from the commissioners. The program that we have before us will not actually go into effect until 2027. Is that fair?
That's my understanding, is that the first eligibility would be the summer of 2027 peak season in SPP.
And you do acknowledge, and you know, in fact, as the commissioners have pointed out, that there are pending proposals before SPP to modify tariffs and documents such that the proposal that you have with Nucor would qualify Evergy for credits within the SPP program in the future if those measures were adopted in tariffs by SPP.
I'm going to object.
This is
I'm
Roger.
sorry,
this
I
Rod-
can't hear you, sir. Say it
Roger
again.
Steiner, Evergy. I'm going to object. The question made an inference that he knew something based on what the commissioner said. And
No, may I respond?
Yes.
I didn't make any inference. I asked him, did he not know? Does he not know this to be the case, that these things are pending before SPP?
I understand that the filing is in front of FERC on potential changes to SPP demand response programs.
I don't think I need to put this into you. Okay.
I'm sorry, I'm hearing some whispers.
Well, that's because
does-
I don't want you to hear them.
I appreciate that, sir.
That does not need to be on the record.
I just heard mumbles, so that's it.
Now I will turn back on. I apologize. I should have turned it off.
All right.
That's all the questions I have.
All right, Mr. Kleiser, on behalf of Public Counsel.
Yes, Your Honor, thank you. Good morning. It's still morning.
Morning.
I would like to pick up on a couple of questions that you received from the Commission's chair. and I'm going to do my best here to paraphrase what I think was the answer. If I get it wrong, please correct me. I'm trying to do my best to make sure I get this accurate. You were effectively asked to give an understanding of what the existing current situation is with regard to resource adequacy, and I think that your answer was that there are no existing Evergy tariffs that would allow for direct participation in the SPP except through MIA. Is that accurate?
The point that I was making is that the MBDR program is a supplement to the BDR program to participate in energy and ancillary service markets and not for resource adequacy.
Okay, but let's go back to just the general idea of, can a customer like Nucor participate directly in SPP, demand response programs, and have that count towards resource adequacy? And your answer was that there are not existing tariffs that would allow Evergy to count that customer for its resource adequacy workbooks. Is that accurate?
Other than MIA BDR.
Correct. My question is there anything preventing Evergy from creating a tariff that would allow direct participation in a manner that would allow a customer like Nucor to count for resource adequacy outside of MIA?
I can't answer that question. That'd be a better question for witness file.
So at least to your knowledge, you're not aware of anything that would prevent Evergy from creating a new tariff that would allow direct participation in SPP in a manner that would allow a customer like Nucor to be counted towards Evergy's resource adequacy workbooks?
This is Roger Steiner with Evergy, and I'm going to object. This question was asked and answered. The witness said he didn't know and asked that witness file be asked the question.
Well,
If I may respond, I do believe he said witness file would be a better answer, but I didn't hear the I don't know that part. I would like to get the I don't know that part on the record.
all right. I'll overrule the objection.
Can you ask the question again?
Naturally. Are you aware of anything that would prevent Evergy from creating a tariff that would allow a customer like Nucor to directly participate in Southwest Power Pool's resource adequacy, demand response programs in a manner that would count towards Evergy's resource adequacy outside of MIA?
I don't know that answer.
Thank you. No further questions.
All right. Mr. Steiner, you have redirect?
A little bit, yes, thanks. Roger Steiner, Evergy. You were discussing with Council for Staff and Council for OPC the resource adequacy issue and whether Nucor could participate at SPP, whether they could participate through MIA. If Nucor is not allowed to participate through MIA, what are the options as far as paper capacity to cover the resource adequacy?
So in Evergy's latest IRP, the 2026 IRP, it solves for meeting the load obligation via multiple different capacity types, owned generation, PPAs, demand response programs, new build, et cetera. And I would say that what I do know about that is that when you look at the MIA BDR all-in costs in the IRP, latest IRP, is that those costs are lower than the assumed paper capacity options for the next several years, 27 through 29 timeframe.
And you talked about the amendment that we're here today to get approved. And is your understanding that that is so Nucor could participate in all DR programs?
Can you repeat the question?
The amendment that we're here trying to get approval for, would that allow participation by Nucor in the entire suite of DR programs that Evergy has, not just MBDR?
The amendment that we are talking about would allow for Nucor to participate in the demand response program that Evergy has available to customers.
Okay. You were asked by counsel for staff if you listened to the opening statements, and you said yes.
I did listen.
Do you recall Mr. Kleiser saying that there was an easy fix?
I'm going to object.
I'm sorry,
was-
again, who's speaking?
I was about to say John Kleiser, apologies. He's attempting to expand the scope of the cross-examination by just referencing opening arguments outside of what was actually discussed on cross-examination.
He was asked if he listened to it. He said he did, and then he was asked several questions about the openings, including your openings. And so
There needs to be a specific cross-question tied to the issue that he wants to redirect on, not just a vague reference to the fact that openings were discussed.
well, I was trying to do that, and then you objected.
I'll sustain the objection.
That's all I have. Thank you.
All right. At this point, let's take a break. We will reconvene at 10:45, going off the record.
Thank you.
All right, we are back on the record, and Evergy, call your next witness.
Company calls to the stand Brian File.
Good morning, Mr. File. Would you raise your right hand, please? Thank you. Do you swear or affirm that the testimony you give today in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
This is Jackie Whipple for the company. Would you please state your name?
My name is Brian File.
By whom are you employed?
Evergy.
And what is your position there?
My position is Director of Demand-Side Management Programs.
In this case, on behalf of Evergy Missouri West, did you prepare and cause to be filed public and confidential direct testimony, public and confidential surrebuttal testimony, and have you offered supporting testimony for the May 18 stipulation and agreement?
I did and I have.
Do you have any corrections to your direct, surrebuttal, or supporting testimony?
Not at this time.
If I were to ask you the questions in each of those testimonies, would your answers be the same?
Yes.
Are those answers true and correct to the best of your knowledge and belief?
Yes.
And to your understanding, is your direct testimony public, labeled as Exhibit 1, direct testimony confidential, labeled as Exhibit 2, surrebuttal testimony public, labeled as Exhibit 3, surrebuttal testimony confidential, labeled as Exhibit 4, testimony in support of non-unanimous stipulation and agreement, Exhibit 7, and is the non-unanimous stipulation agreement that goes with that supporting testimony labeled as Exhibit 8?
Sounds correct.
All right, Your Honor, at this time, I would move to admit, please, Exhibits 1, 2, 3, 4, 7, and 8.
One, two, three, 4, 7, and 8.
That's correct.
Okay. Are there any objections?
Your Honor, Paul Graham speaking for staff. In our filing, in response to the non-unanimous stipulation, we indicated that we did not object, conditioned upon staff's being granted permission to file its testimony. And that testimony to which I refer, we're going to call 105, but it was pre-filed, so to speak, as a attachment to staff's response to the request to approve the non-unanimous stipulation. So we do not object, subject to the Commission's order affirmatively allowing our testimony to come in at this time. And at this time, I would, for the record, tender for admission as an exhibit, and we would call it 105, the attachment that staff made in the EFAS file when it attached that testimony as an exhibit to our suggestions in response to the non-unanimous stipulation.
Your Honor, may I respond?
Yes.
I don't think that we're going to have a problem with staff's testimony ultimately being admitted, but it needs to be admitted with a sponsoring witness, not at this time with the company's witness.
All right, that's fine.
Your Honor, I just want to point out that I also have an objection. This is John
I'm sorry,
Kleiser.
who's-
This is John Kleiser speaking, but I didn't know how quickly you were going to rule, so I just want to make sure you know that I also have an objection.
And what is your objection?
So on May 21st, the Office of Public Counsel filed a response to the company's motion for leave to file additional testimony and included in that an objection to said testimony. And I would renew the objection to the testimony, which has been offered as Exhibit 7 for all the reasons laid out in our filed motion as of May 21st. I can recitate the high level what those are. It was a fairly lengthy objection motion.
All right. I don't know that that's necessary at this time. And I'll withhold ruling on the admission of Exhibit 7 at this time. I will admit Exhibits 1, 2, 3, 4, and 8. As well as Exhibit 105. I mean, I'll hold off on ruling on Exhibit 105.
Thank you, Judge. At this time, we will tender the witness for cross-examination.
All right, Mr. Briscar?
No questions, thank you.
Okay. Mr. Graham? Oh, I'm sorry, Mr. Pringle.
Yes, thank you, Judge. This is Travis Pringle on behalf of staff. Good morning, Mr. File.
Good morning.
Now, I just have a few questions for you. First, kind of about your testimony in general. Your testimony is in support of the Evergy's position and the stipulation agreement, correct?
Correct.
And part of your support for both Evergy's position and the stipulation includes the economic assumptions underlying said agreement, correct?
It includes a financial analysis that would go along with that stipulation, correct.
And part of that would also include projected costs, projected load characteristics, and projected customer participation assumptions?
Maybe make sure I'm talking about the same thing that you're suggesting. The financial analysis would be a post-participation analysis.
Right, but I guess part of your testimony involves how that would carry forward if Nucor were to participate in MIA.
Right, so the participation would be conditional in 2027, and then if they were to participate beyond that, then it would go underneath the normal M&V process that would be post as well, 2029.
And while you're bringing that up, the current MIA Cycle 4, that was approved, at least for Evergy West, in EO 2023-0370, correct?
Sounds right, 69 and 70, one of those two.
And under the non-unanimous stipulation agreement that was approved by the commission, the Evergy Missouri West Demand Response, MIA Business Demand Response Program is currently scheduled to expire at the end of 2027, correct?
Correct.
But the stipulation and agreement, if approved by the commission, would permit Nucor participation through the end of 2029?
The stipulation agreement is tied to the amendment that would need to be approved, which the amendment ties to the SIL contract, which runs through 2029. The stipulation is tied to conditional performance in 2027, and then participation thereafter underneath what tariffs are available under MIA, which.
But if the MIA Business Demand Response Program were to expire at the end of 2027, there is no carve-out in the stip that would let that program exist just for Nucor. Is that a fair description?
There's no specific language to that in the stipulation.
And then also as part of the company's support for Nucor participating in MIA, that involves the usage of avoided costs. Is that correct?
The financial analysis would assume a avoided cost based on our MIA Cycle 4 approved programs.
And just for the record, what is an avoided cost?
Avoided cost / benefit, those terms get used together similarly, but those are an assumption around having to do something otherwise, invest in another supply side resource other than the demand side resource that is being employed. It goes for efficiency, demand response, both.
And now,
I'm sorry, the last words, sir?
Sorry, energy efficiency and demand response, or both, and both. Yeah.
and then this is currently the fourth MIA cycle that Evergy has administered, correct?
Correct.
And the previous MIA cycle was approved in EO 2019-0132. Does that sound correct?
Sounds right. I think there was two numbers again, but yeah.
And then at least for that MIA cycle, there was an ordered avoided cost number, correct?
That was a contentious issue in that case that then became very specific in the order, correct?
Now, for the commission orders approving the stipulation agreements for MIA Cycle 4, there was no explicit avoided cost number that was ordered, correct?
They did not insert a avoided cost number in the order.
And then do you have a copy of your surrebuttal testimony up there with you?
Yeah, I think so.
When you get a chance, go to page 3, lines 14 and 15. Let me know when you're there.
I think I'm there.
All right. And do you see the phrase that says, and I quote, "While not explicit in the way MIA Cycle 3 was outlined in the order, implicitly the MPSC approved the avoided costs by approving the Cycle 4 stipulation and agreement," end quote. Do you see that?
I do.
And so I guess just to kind of paraphrase that, there is no explicit approved avoided cost number for MIA Cycle 4.
Object to the extent it calls for a legal conclusion.
Simply asking the witness to confirm that there is no avoided cost number ordered by the commission.
Same objection.
Thank you, Judge.
I'll overrule the objection.
It was not explicit in the way MIA Cycle 3 was. With this testimony, I agree.
I'm sorry, it was not explicit in the way,
The MIA Cycle 3 order was.
And also, is it your understanding that the other signatories to the agreement understood that the commission was implicitly approving the avoided costs within the company's MIA Cycle 4 application?
I don't know that I could speak for what they thought, if it was implicit or explicit, if that was your question.
Yes, thank you, Mr. File. Now, I kind of want to talk a little bit more about the costs involved with Nucor and its volatility. Would you agree with me if I say that Nucor is a unique customer for Evergy?
I think that's fair.
And now, also, would you agree that Nucor is a very large customer for Evergy?
They historically have been very large.
And would you characterize their load as materially different from, let's say, commercial customers?
What's an example of a commercial customer there that you're speaking of?
Let's think about a Walmart.
Yes, Nucor would be different in terms of electric profile usage than a Walmart, correct?
And really, would you say that Nucor's load profile differs from other industrial customers served by Evergy Missouri West?
I would say that it depends on how far you want to slice the different types of customers that are industrial customers in terms of what they manufacture, how their processes are set up, and ultimately how much energy intensive they are. You could probably granularly slice up that industrial processes quite thin, but to my knowledge, we don't have anyone to the size or basically to the size and arc furnace the way Nucor is, if that's.
And then kind of speaking on that arc furnace, Nucor's operations are highly dependent on, well, when they need to produce steel. Is that fair to say?
It'd be a little bit of a guess at that point in time. I mean, right, they're there to make steel, so therefore, when they're operating, they're making steel. I'm not sure if I'm following you.
So I guess it's a reasonable inference that their operations are primarily based on when they need to make steel.
Sure.
And now when it comes to the energy needed to process this steel, it's fair to say that Nucor can ramp up pretty quick.
I don't know that I could speak to that.
Well, I guess then, when Nucor does need to be in full operation, it carries with it a significant load in the eyes of Evergy Missouri West.
When Nucor is operating, they have a significant load, sure.
And that load, is it fair to say that that load can fluctuate?
Help me define fluctuate.
Okay, let's say it can go from, let's say at any time it could maybe be around 18, 19 megawatts, to all of a sudden it goes up to 30 megawatts, goes down back down to 10 megawatts, something like that.
From my observations of their load profile curves, and I put a little bit of that in some of my rebuttal testimony, they do have variations over hourly basis, in which hourly is important for what we do in demand response. But everyone's load changes a little bit all the time, right? It's a question of what's that bandwidth as a fluctuation versus a normal variation, kind of all those things.
And kind of with that fluctuation in mind, let's say, would it be possible for you or Evergy Missouri West today to tell us what Nucor's load will look like tomorrow at 2:15 p.m.?
I don't know that I can answer that, what it would look like tomorrow at 2:15 p.m.
Would it be possible to say what it looked like today at 2:15 p.m.?
I think we could make a reasonable assumption, hence what M&V does. Everything we do in energy efficient demand response is measuring what didn't happen, right? There's lots of sophisticated energy modeling, statistical analysis that does that. But at the end of the day, right, we're predicting the future or predicting what didn't happen. So that's true of any program that we run.
But when it comes to the EM&V, you just pointed out, that is a post-performance measurement. EM&V wouldn't be used to go ahead and set a baseline, as to more to confirm whether that baseline was met or not.
Can you rephrase just to make sure I'm tracking you?
Like a EM&V, or evaluation, measurement, and verification, it's not used to set a baseline for a participating customer, correct?
They ultimately do, to determine the performance of that customer, if that's what you're asking?
Correct, yeah.
Okay, so yeah, the EM&V does set a baseline for the customer.
But that is post the fact that an event has been called by Evergy.
Yeah, they look at all the historical data and then decide what they would have used during that period of time, correct?
And part of that also is, as you're kind of making those assumptions, they need to be as accurate as possible. Is that fair to say?
Sure.
Now, if those assumptions, if those forecasts are not correct, it could lead to the benefits modeled by the company being over or undervalued. Is that fair to say?
What do you mean by not correct?
Let's say if, the company has this idea that on day X, Nucor will be able to curtail Y amount of megawatts, but in fact day X comes and instead Nucor only curtails Z amount of megawatts. Could that affect the potential benefits that other customers would realize?
Let me make sure I'm tracking your question and repeat it back here. So if a customer we thought was going to participate with Y and only participated with Z as we look at after the fact,
Yes.
how would that affect other customers in our programs?
Right. How could that affect the benefits that the company is projecting would be enjoyed by all customers?
Yeah. So the MIA demand response program has set up to pay for performance, so it would only pay on the Z level that the customer performed at. If that was less than the Y, right, we'd have to figure out, did someone else overperform, or how do we make sure that we get the total that we need? But the individual customer would only get paid on what they performed with.
And then when it comes to payment for performance, that would also apply to any participation through an SPP demand response program as well, correct?
If a customer is bidding their registered demand response into the market, how does that work? Is that your question?
Yeah, we would still be, I guess SPP would verify performance before any bill credits or payouts.
Yeah, they have a performance monitoring basically process in order to kind of validate what the payment is, what they performed or didn't perform, and what the price was and all that.
And then also when it comes to any kind of participation by Nucor and MIA, that would also come with it administrative costs for that participation, correct?
Yeah, we have administrative costs to recruit customers, to manage and be able to call them with our systems, and then obviously evaluation and costs also run through that.
And for MIA participation, is the company able to allocate specific administrative costs to specific participants?
We typically allocate them at the program level, so the whole MIA demand response program and any other program will get those costs allocated that way.
But would the company be able to determine the exact amount of administrative costs for Nucor's participation?
We could allocate based on kind of proportions or other methodologies to assign, but typically it's at the program level, which is where kind of cost effectiveness is done at the normal basis, right?
And then I guess when it comes to those administrative costs, the company does not see those as part of the cost of serving Nucor if Nucor were to participate in MIA?
The costs associated with MIA demand response, if Nucor was going to participate in MIA demand response, would not be the cost to serve electricity to Nucor. That's our position.
And that's part of why the company has that position of the hold harmless portion of the SIL agreement should not apply.
But the cost of MIA demand response not going there, correct?
I'm sorry, say it again, sir. The cost
The
of,
cost of MIA demand response should not go into the SIL hold harmless calculation, is our position correct?
And then also, if Nucor were to participate in the MIA business demand response program, are there incremental costs associated with that participation?
I think this is maybe a nuance of the question, but the commission authorized all of MIA Cycle 4's demand response with the targets associated with that, which has a budget and assumed cost for all participation. Our proposal is to include Nucor inside of the already approved level of costs. So while Nucor would effectuate some of those costs, right, those costs are already approved as part of our cycle. So not technically incremental, but part of what's already been approved.
Now, it's also true that at the time that the commission approved Evergy's MIA Cycle 4, Nucor was prohibited from participating in that cycle due to the SIL language.
They were not allowed to participate, hence the amendment request.
Okay. One moment, Mr. File.
Sure.
And I think I got my last little few questions for you, Mr. File. Now, Nucor has participated in MIA business demand response in the past, correct?
They have.
And that was under Evergy's Cycle 3 MIA program?
Correct.
And that participation was in spite of the SIL language prohibiting such participation?
This was before that became aware that was an issue. Yep.
And then I guess it's fair to say that a lot of the supposed benefits that the company is projecting is based on Nucor participation during MIA Cycle 3?
Can you rephrase just to make sure I'm answering that right?
Yeah. Is it fair to say that part of the projections for the benefits from Nucor participation in the MIA Cycle 4 business demand response is based on what the company learned during that Cycle 3 participation?
We generally, and have talked to Nucor about participating similarly than they did in Cycle 3 with the amount of KW they could reduce, but in Cycle 4, if that's your question.
Yeah.
Yes.
And the, I guess the avoided costs being used for Nucor participation in Cycle 4, those differ from what was used in Cycle 3, correct?
Yeah, what we believe is the implicitly approved avoided costs for Cycle 4 are different than Cycle 3.
Okay. I appreciate your time, Mr. File. No further questions.
Thanks, Mr. Pringle.
Mr. Kleiser.
Good morning, Mr. File.
Hey, good morning.
Were you here when I was having a conversation earlier with Mr. Meitner?
I was.
So then you were probably aware that I had a question for him and that he oh so generously pitched it on to you. Do you recall that?
I elbowed him afterwards just so that...
Well, thank you. So obviously my question is the same one, and I'm going to do my best to try and get it from memory. So what is currently preventing Evergy from creating a new tariff that would allow a customer like Nucor to participate directly in a SPP demand response program outside of MIA in a manner that would allow them to be counted for Evergy's resource adequacy workbooks.
So, having been close to tariffs in general related to MIA and demand response, I'd say this. There'd be a problem, but we could do it.
All right, thank you very much. I have no further questions.
All right. Are there questions from the commissioners? Chair Hahn.
Good morning.
Morning.
In your rebuttal, you talked about the verified peak demand reductions that Nucor had experienced during MIA Cycle 3. There's some arguments that it's difficult to quantify those reductions because of the load profile of Nucor. Seems as though you've done it. Can you talk through how you did it and how you made those assumptions with relation to a baseline and how you can verify that those are real reductions?
Yeah. So, in my testimony, basically what I'm doing is sharing what a third party has done in this process. So, you may be familiar in the MIA process, we have a third party who evaluates all of our programs. And historically, we've then had a staff auditor audit that third party. So what I've explained in testimony is that that third party, and ADM Associates, I think our counsel mentioned that at the beginning, goes through and looks at very similar days leading up into the day that we call an event, and then tries to use that to best model what their load would have been had we not called an event. And so there's a particular issue, I think, in some of these where we look at 9 of the last 10 similar days. They say 9 of 10 because they throw out one. There's always an anomaly that something doesn't make sense. Maybe they had a O&M or operations day or a maintenance day that day where they weren't running. Okay, so that probably doesn't make sense to include in the baseline. So they look at 9 of 10, and then they create an hourly profile of what their load would have looked like during that. And it can have some ups and downs in it. And again, in the testimony, there's even a little bit of charts around that. It has some little ups and downs, but it has basically a curve. And then the important part then is how do you measure that against what their load actually was? Because we have meter data to say what there actually was. And so then they'll do that and validate that KW between those two to say this is what that performance was. The important next step that's kind of talked about, we turn that information in from a third party that they evaluated into SPP to say, does this meet the rules and parameters of SPP's demand response for resource adequacy? So then they go through that next step of kind of validating that so we can put in our resource adequacy notebooks.
Thank you. One other question, I'm just trying to recall from reading. There were, I think it was 7 events over Cycle 3 that were responded to. Were there any events where Nucor was called on and did not show up, did not respond?
No.
Okay, thank you.
Any other questions from the commissioners?
Judge, if I may, it's Commissioner Mitchell.
Go ahead, Commissioner.
Yeah, I was in your rebuttal or around page 4. You talk about the calculation of the benefit cost ratio, and that was in program year 2021, 2022. And I'm curious if there are other program years that where the data bears out the greater than 2.0 cost benefit ratio.
For Nucor specifically, that was the only years they participated, and so we honed in on the benefits during the years they participated. But overall, all of our MIA demand response programs go through the same cost benefit test to determine that cost effectiveness level, and they would have been on the order very similarly to the benefit to cost ratio when you look at 23, 24, 25, as you kind of continue on without Nucor, but that would have been the entirety of the group.
Okay, well, that helps me understand why 2021 and 2022 were the only years that where the data shows up in that calculation. So thank you. I appreciate that.
Yeah, sure.
All right. I've got a few questions myself, and this, I'm going to start and refer to your direct testimony.
Okay.
On page 14,
Okay.
the question you were asked was, why is it prudent and reasonable for the commission to approve the amendment allowing Nucor Sedalia to participate in EMW demand response programs? And within the answer to that question, you listed off 4 items. And at the bottom of the page, number 4, you state existing programs ensure non-Nucor EMW customers are not harmed by Nucor's participation in MIA demand response programs. Can you elaborate on what you mean by existing protections?
Yeah, that number 4 was primarily in reference to the SIL tariff and the protections associated with all customers in that tariff.
Okay. Here, let me find this. Have you reviewed public counsel witness Mansell Payne's rebuttal?
To some degree, but it probably need refreshed depending on what you want to ask.
Okay, let me see if I can find this. This is in response, this is on page 3 of that rebuttal testimony. And the question was asked of him, can you provide any background as to the connection between Evergy's MIA business demand response programs and Nucor's SIL tariff? And part of the answer states, the commission approved a unanimous stipulation agreement in EO-2023-0407 and EO-2023-0408 to solve all issues regarding Nucor's participation in EMW's MIA Cycle 3. Now in MIA Cycle 4, EMW wants to include Nucor in their MIA BDR program, only this time they are requesting permission to do so. However, the targets for the MIA BDR program, and then in parentheses 140 megawatts in 2026 and 150 MW in 2027, have not changed. Those targets were set without the inclusion of Nucor, which means including Nucor now would create the same problem identified in the MIA prudence review cases, where EMW used Nucor to meet the targets, or meet its targets easier, resulting in an unjustified earnings opportunity and incentives for EMW and Nucor, respectively. Do you agree with that statement?
Judge, may I give the witness a copy, please,
Sure.
of that testimony you're reading? Okay.
And that was Ms. Whipple.
Okay. Sorry about that. I should have said something before, but I did not have it. You're asking, do I agree with that answer?
Right. Do you agree with that position, for lack of a better term?
The position that Evergy would make it easier to achieve their Cycle 4 targets, I think is a concern that was raised, and I can understand why it was raised. The stipulation agreement that we put forth attempts to resolve that by, if maybe you recall, our MIA demand response has a threshold for achievement where we must achieve 65% or we get 0 earnings opportunity. and that was contemplated without Nucor. So you could do different ways to kind of solve that, but we've effectively said, well, Nucor won't count towards that 65. So we got to get to 65% with everybody else, and then to achieve earnings opportunity. So we agree that the target, that threshold wasn't contemplated with Nucor, and we're trying to solve that in a different way. I think that may have answered your question.
I think so too. Referring to the stipulation and agreement, if you can refer to that, please.
I think I might need that one more time. Brought the Sorry for being an unprepared witness here. Apologize about that.
All right, on page 1, the second paragraph, second numbered paragraph, it says SIL contract amendment. The signatories agree to insert language in Nucor SIL contract amendment stating the approval of the amendment by the Missouri Public Service Commission is conditional for 2027. And then the first bullet point says, if a financial analysis of Nucor's participation in business demand response shows net benefit to all customers, Commission approval of this settlement and contract amendment will be automatically extended for the term of the SIL contract term, and then in parentheses, currently through 2029, or any authorized extension. How will you calculate the net benefit to all customers?
Yeah, the financial analysis is related to how we typically do demand response at the program level, but the request here, or the stipulation here, is to do it at the participant level. So all of the costs associated with the incentive and the evaluation and the things that we can allocate, kind of going back to Mr. Pringle's questions before, to that customer, contrasted with what is the avoided cost or the alternative resource that we would have to put into service if we didn't have demand response in our resource adequacy stack.
Okay.
So benefits minus the cost than what they allocated.
All right. Those are the only questions I have at this time. Mr. Briscar, is there any recross on behalf of Nucor?
No, Your Honor.
Mr. Pringle, on behalf of staff?
Yes, Judge, thank you. Travis Pringle on behalf of staff. And Mr. File, just a few follow-up on some of these resource adequacy questions. It is true that, I guess, for the purpose of any SPP resource adequacy in 2026, it is too late for Nucor to make a change to that, correct?
Summer of 2026 is passed. Yes, we turn that into May 15th.
All right. And then, so I guess for the purposes of, this case in resource adequacy, Nucor participation as of now, based on the currently approved MIA, would just be for next summer.
Correct.
And then also kind of when it came to the 7 events that were called with, and those 7 events were responded to by Nucor, correct? Do you know when it comes to these events?
I'm sorry, I didn't get an answer on there.
Oh, sorry. The head shake was inaudible. Yes.
Yeah, I can confirm the witness nodded affirmative. When it comes to those events, are you aware if any of them were called around any pre-planned maintenance that Nucor was already undergoing?
I'm not aware if that was the case.
Does Evergy do any kind of due diligence to ensure that there isn't a already pre-planned maintenance or outage in place when an event is called?
What we do to better understand kind of implications of where a customer is in terms of participation is we have a weekly meeting on Mondays to evaluate kind of what do we look for in terms of expectations for demand response events. And we also include our key account folks who know if certain customers are off for maintenance or for those sorts of things too. So they can communicate that sort of thing during those weekly meetings. That's a typical process.
Okay, and would the fact that there is a scheduled maintenance affect Evergy's decision to call an event?
It may.
Okay. One moment, Judge. I guess finally for you, Mr. File, I have kind of just a question about verified peak demand reductions. How does, to your knowledge, SPP account for variation in expected load compared to actual performance?
I'm going to object that that's beyond the scope.
So this is part of the SPP resource adequacy accreditation, which I believe were questions asked by the bench.
Ms. Whipple?
It is very, if it's related to it, it is very tangentially related to it, that there were not any bench questions on this topic.
I'll sustain the objection.
I guess, and finally, when it comes to the allocation of any kind of incentive costs, would it be possible for the company to separate incentive payments to Nucor from those sent to other customers participating in MIA business demand response?
I'm going to object to beyond the scope as well.
This question regarding allocation, which the witness testified pretty extensively to in response to questions from the bench,
It's a question about allocation of incentives, which was not discussed by the bench.
which the witness himself actually said incentive costs.
All right, I'm going to overrule that objection.
Thank you, Judge.
The short answer is we know exactly how much incentive we would pay Nucor. Yes.
Yes, and that could be separated from, I guess, the pot of the other incentive money if needed.
Yes.
Thank you for your time, Mr. File. No further questions.
All right, Mr. Kleiser, do you have recross for this witness?
I do not. Thank you, Your Honor.
Thank you. Ms. Whipple, any redirect?
Briefly, thank you. In conversations with Chair Hahn and just now with Mr. Pringle, you discussed the 7 events where Nucor previously curtailed as called, correct?
Yes.
If an event is called and Nucor was already down for maintenance, I think that was the example given, is demand reduction still achieved in that event?
So when a customer does not respond, I think, is that your question? Because they're already...
Because they're already down?
Yeah.
Yes.
Because they're already down. Yeah, that's taken into account in the pay for performance, ultimately, as how we validate what they did and what they didn't do.
And in that event, do customers still benefit from demand reduction?
So ultimately in resource adequacy, where the customer can test and get down to in terms of their performance and the megawatts that they're assigned with it is kind of their own function, right? They can do that, right? So if they, maybe to put a specific example here, so if the day before they know we're going to have an event, right? They take that action however they want to get that demand reduction.
Thank you. In response to cross from Mr. Kleiser, you said there'd be a problem, but we could do it. Do you recall that conversation you were having with Mr. Kleiser?
Was it about the tariffs?
Yes.
I do.
What did you mean by there'd be a problem, but we could do it?
I believe he was referring to, can we change, for example, the market-based demand response program to be inclusive of resource adequacy by participating in SPP's programs? You could change the tariff in that way, but it would be basically kind of flip reverse of the purpose, right? So our MIA demand response is a resource adequacy product. We tie it with market-based demand response to be energy ancillary markets, right? So if they want to participate more, contribute more, take some market opportunities that have some financial benefit for them, they can. But the primary value and the value we pay for is for the resource adequacy. If you changed the market-based demand response to that be the primary, the customer commitment would have to be similar to what SPP requires, which is you're bidding that demand response in the market almost on a daily basis. And that level of commitment is a totally different kind of customer commitment and value proposition, financial value proposition, that to date we haven't seen customers buy into because the economics haven't made sense for them to be in the market that much with their demand response.
Are there any participants in Evergy's MBDR tariff at this time?
Not today.
And is that because of what you were just referring to?
Correct.
Are there other problems associated with just editing the tariff so that Nucor could participate in SPP programs along the lines of Mr. Kleiser's question?
Other than, unlikely to have participants in the program based on kind of what we see as the financials there, they do have to meet additional requirements that are above and beyond what resource adequacy is required that we turn into SPP. So it's almost like extra work, extra cost without any extra benefit in terms of resource adequacy. So that seems to be the biggest part. We'd have to recover those costs, or the customer would have to recover those costs in some way if they participated through SPP's program.
If I understood you correctly, you're saying it may actually be more costly for a customer to participate in that fashion. Is that correct?
Potentially.
Okay. Thank you. No more questions.
All right. May this witness be excused. All right. Thank you for your testimony.
Thank you.
All right. Ms. Whipple, Mr. Steiner.
Judge, our third witness is not here yet, but she should be arriving shortly, and if we took a lunch break, she would arrive during the lunch break, and then we could put her on the stand after that, if that's palatable for everyone. Otherwise, we'll need to proceed with another party at this time and take her out of order.
All right. We will go ahead and break for lunch now and reconvene at 12:45. So let's go off the record. All right, let's go back on the record. Mr. Steiner, is your witness here?
This is Roger Steiner with Evergy, and Linda Nunn is here, and we call her as our next witness.
Okay. All right. Ms. Nunn, would you raise your right hand, please? Thank you. Do you swear or affirm that the testimony you give today in this hearing shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Please state your name.
My name is Linda Nunn, N-U-N-N,
By whom are you employed?
Evergy Incorporated.
And what is your position there?
I am a senior manager in regulatory affairs.
In this case, on behalf of Evergy Missouri West, did you prepare surrebuttal testimony which has been marked as Exhibit 6?
I did.
Do you have any corrections to your surrebuttal testimony?
I do not.
If I were to ask you the questions in your surrebuttal testimony, would your answers be as set forth in Exhibit 6?
Yes,
Are those answers true and correct to the best of your knowledge and belief?
they are.
Your Honor, at this time, I'd move to admit Exhibit 6.
Any objection? Exhibit 6 is admitted.
Thank you, and now I would tender the witness for cross-examination.
Mr. Briscar, is there any cross-examination on behalf of Nucor?
No cross.
All right. On behalf of staff?
Yes, Judge, thank you. This
Mr.
is
Pringle.
Travis Pringle for staff. Good afternoon, Ms. Nunn.
Good afternoon.
And just kind of for the record, what were the years that Nucor previously participated in Evergy Missouri West's Business Demand Response MIA program?
That's not part of my knowledge. I mean, another member of the team would know that information. I'm more of the accounting side.
Do you have any reason to doubt that it was 2021, 2022?
No.
And then when it came to that past participation, did Evergy reduce the actual contracted capacity purchases based on participation from Nucor over those years?
My understanding is that during that time, the capacity level was adequate to cover Nucor's costs.
So overall, that's a yes?
That's as much as I understand about what you were asking, capacity-wise.
And then also you have testimony regarding the hold harmless provision from the SIL?
Yes,
And it is the company's position that any administrative costs or incentive costs from Nucor participation in MIA should not be included in that hold harmless,
that is correct.
because the company does not believe that would be a cost of service for serving Nucor.
For serving electricity to Nucor, that's correct.
One moment, Judge. Thank you for your time, Ms. Nunn.
Thank
No further questions, Judge.
Thank you. Mr. Kleiser, any cross on behalf of the public counsel?
No, thank you, Your Honor.
Do the commissioners have any questions for the witness? All right. Any redirect?
Yes, very briefly, thank you. Ms. Nunn, you were asked by Mr. Pringle here, why you believe the SIL hold harmless calculation is different from cost to serve under the MIA BDR program. Could you please elaborate?
In the original agreement, it very specifically says what types of costs need to be included and compared to revenues in the hold harmless calculation during a rate case. And each of those costs are identifiable as costs to provide electricity to Nucor.
And for those a little less familiar with accounting, What's different about providing electric service to Nucor versus Nucor participating in the MIA BDR program? Why would those things be
Objection
distinct?
beyond the scope.
It's a clarifying question to the question that was already asked and the witness's response there too.
I'll overrule the objection. You can answer the question.
So the MIA benefits and costs are all part of that MIA construct, and then the hold harmless is completely separate, and it is part of the rate case analysis of the cost to produce electricity for Nucor.
What would happen if the costs associated with Nucor's participation in the MIA program was to be routed through the SIL tariff's hold harmless calculation? What would happen then?
There would be an unbalance as to cost and benefit.
And what does that mean?
That means that you would just be looking at one side of the equation and not the whole picture.
What impact would that have on shareholders or customers?
Shareholders would be completely responsible for all the costs associated with the demand response program regarding Nucor.
Regarding Nucor?
I'm sorry.
And who would get the benefits under that scenario?
All other customers.
Not the shareholders who'd be paying all the costs?
Correct.
Okay, understood. Thank you so much. No further questions.
All right. Thank you. Thank you, Ms. Nunn, for your testimony.
Thank you.
And my understanding is that concludes your witnesses?
It does. Thank
Okay.
you, Your Honor.
All right, staff of the commission, would you like to call your first witness?
Yes, Judge, just doing a little musical chairs real quick as we get ready to call our first witness.
Staff calls Justin Tevy.
Mr. Tevye, would you raise your right hand, please? Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you. And
For the record, this is Ray Canine for staff counsel. Good afternoon, Mr. Tevy. Can you please,
Afternoon.
could you please state your name and spell it for the record?
Justin Tevye, Justin. Last name is Tevie.
Thank you. And how are you employed?
By the Missouri Public Service Commission.
Did you prepare or cause to be prepared rebuttal testimony in this matter marked as Exhibit 102?
Yes.
Do you have any changes or corrections to your testimony?
Yes.
Could you state that correction?
On page 8, line 3, it should read January 1, 2029.
Thank you. Are there any other corrections at this time?
No.
Are the answers contained in the testimony true and correct to the best of your knowledge and belief?
Yes.
If I ask you those same questions today, would any of those answers change?
No.
I move for admission of Exhibit 102.
are there any objections? Exhibit 102 is admitted.
Mr. Tevy, did you contribute to the testimony in Exhibit 105? Mr. Tevy, 105 would be the testimony attached to the opposition to the amendment and agreement.
The memo?
Yes.
Yes, I did contribute.
Okay, thank you. I move for admission of Exhibit 105.
Well, first of all, I'm not exactly clear what Exhibit 105 is. So can you direct me in EFIS, I assume, to where that testimony is?
Your Honor, this is Paul Graham speaking for the staff. This was the subject matter that we talked about this morning. Exhibit 105 is the memorandum of testimony that was attached as an exhibit or referred to as an exhibit in the suggestions that staff filed in response to the stipulation.
Okay.
And so
And-
this is one of the sponsoring witnesses. There are two more sponsoring witnesses.
Okay. And that is,
Now, we are
it's,
calling it 105.
right, and it's 8 pages, numbered pages, line numbered pages.
That's exactly what it is.
Okay, and it actually is headed on the first page, memorandum specific objections,
Yes.
correct?
Yes.
Okay,
And the exhibits 103 and 104, which Ray just mentioned to you, are attachments to that memorandum. So the three come in together, but this witness is one of 3 sponsoring witnesses for the whole thing. It's not ready to come in through him. We'll have 2 more witnesses. Sorry to confuse.
all right. Are there objections to the admission of Exhibit 105?
At this time, yes, because I think staff has to put all of their witnesses up who have contributed in part to this exhibit and any attachments, and can't get the whole thing in on only one sponsoring witness who contributed only partially.
Staff agrees with counsel on that. We would wait till the third witness testifies.
And that is Mr. Graham.
That is correct.
Well, no, now,
No, he's talking about who was talking.
oh,
Yeah.
okay.
Oh, no, I wasn't implying that you were going to be the witness.
Well, I was blamed for objections earlier that I didn't make.
This is Ray Canine for staff. I tender the witness for cross-examination.
Okay, and Mr. Kleiser, do you have cross?
Yes, hopefully briefly. Good afternoon, Mr. Tevy.
Good afternoon.
Originally, I hadn't prepared cross, but some of the earlier conversations today got me confused, and I want to just get your help in understanding something. So can I direct you to your rebuttal testimony, page 8?
Yes, I'm there.
And I just want to understand how this customer baseline model works. So according to what you have written here, starting at line 17, you talk, for this type of baseline, the hourly load is the average hourly load taken from the highest 9 out of 10 prior non-event, non-holiday weekdays for weekday events. Am I correct in interpreting that to mean that when you're setting the baseline, you just look at the 10 days prior to when an event was called and pick the 9 highest?
9 of 10 average, the 9 of 10.
Right, so it's just the 10 that came before whatever the event was called, is that accurate?
Yes. And these are, as I mentioned, non-holiday weekdays.
Oh, so you exclude days where you would expect them not to be operating effectively?
Yeah, holiday, it's non-holiday weekdays.
Got it.
Yeah.
Okay. And so the idea is that those 9 of 10 days would be consistent and therefore could give you an average baseline. Is that how that works?
Yes.
All right.
From the DR response I received from Evergy, that was my interpretation, yeah.
Okay, so is this something Evergy does, something the EM and V people do, something staff does, or who is doing this?
So, let me just read the DR response. So the DR response says the EM and V baseline method was a 9 of 10 on adjusted customer baseline model.
So it's the EM&V group that's doing this? Is that?
From my understanding, yes.
Okay. And just to make sure I understand staff's issue correctly, basically what you're saying is you don't think that 9 of 10 days gives you a reliable baseline because of fluctuations?
Judge, I'm going to object to this question. It's friendly cross. Staff's position is entirely adopted by OPC. The point of cross-examination is to test testimony that is not in the interest of your party, not perpetuate testimony that is purely in the interest of the party you represent, and that's exactly what's going on here. It's unfair and it should stop.
Mr. Kleiser?
You know what? Honestly, I don't think that that's a grounds for it, but I'll be completely honest, I don't need that last question. My real goal was just to have a better understanding of how this baseline works, and I have achieved that. So that was the extent of my cross. Thank you very much.
Mr. Briscar, any cross on behalf of Nucor?
Yes, Your Honor. Good afternoon, Mr. Tevi.
Good afternoon.
My name is Joseph Briscar. I represent Nucor Steel Sedalia in this matter. How are you today?
Good.
Good. Do you have a copy of your testimony in front of you?
Yes, I do.
Okay. I'm going to ask you a few questions about your testimony. Generally speaking, according to your testimony, you're broadly familiar with Evergy's demand response programs, including the MEEIA programs, right?
The right person will be Mark Kisling or Jordan Hu. I have a very general idea about demand response, but not Evergy's demand response. Yeah.
Okay, so you're not necessarily testifying to the specifics of the business demand response program?
No, the right witness will be Jordan Hu, staff witness Jordan Hu. Yeah.
But you can testify to demand response programs generally?
At this point, no. I just wrote about the baseline method, but I related the baseline method to the demand reductions, which can be, or the demand savings, which can be achieved. But I didn't write testimony on the demand response program itself.
Okay, well, let's just go through a little bit of your testimony then.
Okay.
Can you turn to page 3, please? Page 3. This is your rebuttal testimony. I mean, the rebuttal testimony, right, yeah. Beginning on line 7, there's a question. What are the benefits and costs of the MIA demand response program? And you answer on line 8, the benefits will accrue to Nucor in the form of a discounted bill. You see that?
Yes, sir.
Well, first, before we get into the answer, the question asks about your understanding of the MEA demand response programs, right?
Yes, the MIA demand response program, yeah.
And just a minute ago, when I asked you, you said you weren't testifying to the MIA demand response programs, and you had no knowledge of it.
Well,
I'm
I
gonna
told you.
object. This is Ray Kaneen. I think he's mischaracterizing testimony.
I'm going to overrule the objection. You can answer the question.
So I said I had a general idea, but not into detail, because the question was more specific about the demand response program, and I don't have any detailed knowledge of the MIA demand response program, but I do have a general knowledge, yeah.
Okay, I'm just trying to lay the foundation to understand what it is you're testifying to and what you're able to testify to.
Okay.
So I'm just looking at your testimony, and we're going to go from there, all right?
Okay.
Okay, so specific to your answer to the question, you say that the benefits will accrue to Nucor in the form of discounted bill, is that right?
Yes.
Is it your position that the MIA demand response programs only provide benefits to participating customers?
There are also some costs involved.
Okay, well, I'm asking specifically about the benefits, though.
Well, it should provide benefits to customers.
So it will provide benefits not only to Nucor, but to other customers, is that right?
Yes.
Okay, and let's explore some of those other benefits. Demand response programs can provide, can help reduce Evergy's capacity obligation, right?
Yes.
And in addition to avoided capacity costs, demand response can help provide reliability benefits. Need an example?
No, but these questions are outside the scope of my testimony, because my testimony wasn't to talk about avoided capacity costs or reliability. There's a staff witness responsible for that.
But your testimony does go to the benefits that will accrue under the MEA programs, right?
Yes, it does talk about the benefits, yeah.
Okay. In terms of a reliability benefit, let's say that curtailing a load at a time of system stress could help prevent brownouts or blackouts, right? Is that a yes?
Yes.
Thank you. And if a curtailable customer is curtailed at the time of the system peak, that would help reduce the overall system peak, is that right?
That's correct.
Okay. And so each of these areas, avoided capacity, lower system peaks, those are potential benefits of demand response programs.
Yes.
Okay. So if Nucor participated in the business demand response program, it's not that the only benefits would be a discounted bill to Nucor. It's possible that we would see these other benefits as well, correct?
It's possible, but my discussion of the benefits was with respect to the baseline and how the reduction of how the reduction from the baseline would create some benefits. But like I said before, I'm not the right expert for these kind of questions.
Okay, and
Yeah.
just to clarify on those benefits and getting to more of those specifics, which witness did you say that would be better for?
I think that will be staff witness Mark Kisling or Jordan Ho.
Okay.
Yeah.
Well, then let's turn to the section of your testimony where you talk about this load forecast for Nucor. Beginning, let's look at page 9.
Yes, I'm there.
Okay, beginning on lines 6 and through 9, the question is, does Evergy have the ability to accurately forecast Nucor's load? To which you respond, no, due to the level of volatility surrounding the load, it is unpredictable. The unpredictability of the load implies that Evergy cannot accurately forecast the peak demand reduction that would result from calling a demand response event. Is that correct?
Yes.
Is it your position that Nucor should be disqualified from participating in the business demand response program because its load is unpredictable?
Well, if the load is difficult to forecast, right, then it might be difficult to pin down the baseline. If we cannot pin down the baseline, then it's difficult to measure or calculate the demand reductions or the savings. So that's what I was trying to say.
Are you aware of any other customers who wanted to participate in the business demand response program who were barred from doing so because of their load shape or their unique load characteristics?
No.
Are there any specific requirements in the MIA program restricting customers with unpredictable loads from participating?
I'm not aware of this.
One moment, please.
That's all, thank you.
All right. Ms. Whipple, do you have cross?
No, thank you, Judge.
Do the commissioners have any questions for the witness? All right. Any redirect?
Mr. Tevy, you talked about the baseline model, a 9 out of 10 average. You have reviewed Nucor's load over the period of time, correct?
Yes, I did.
How volatile is Nucor's load?
I do have some graphs on pages 9 through 11 to show the extent of volatility in the load.
Can you describe how that volatility looks on those graphs?
Judge, I'm going to interpose an objection at this point. I think it's beyond the scope of cross-examination, and on top of that, it only relates to the friendly cross that was offered by OPC, and that's part of the problem with friendly cross is getting the witness to say something on the stand that then allows open redirect by the party, and these are both parties who are perpetuating testimony only in their interests. So kind of a double-layered objection at this point.
Judge, and I'm just going to say that I think everybody that's crossed Mr. Tevy at this time has kind of hinted towards this volatility, and I'm just trying to get to the bottom of it.
All right, I'm going to overrule the objection, but will remind you that it appears that the information on those graphs is confidential.
Just one more time, could you describe how that volatility is represented in your graph, Mr. Tevy?
Well, it shows some highs and lows, right?
With these highs and lows, is that a fluctuation?
Yes, it's a fluctuation.
Is this fluctuation hourly, daily, monthly?
This graph, I present 15-minute intervals and then hourly intervals.
Thank you. One moment, please. And the next one. Okay. Back to Nucor's question about your load forecast. How would you measure the difference if you can't find a reasonable baseline?
Staff attached effect document, which describes or proposes, prescriptions for finding a reliable baseline in that document.
Could you expand on what your understanding of that is?
Well, the document describes how to establish the baseline window, how to calculate the baseline itself, and then any adjustments to make to the baseline.
Excuse me, this is Judge Sire. Mr. Tevy, did you say fake document?
Oh, FERC.
Oh, FERC,
sorry.
F-E-R-C.
Federal Energy Regulatory Commission.
Okay, thank you.
Nothing further from staff, Judge.
All right. Mr. Tevy, thank you for your testimony.
Thank you.
Staff may call their next witness.
Thank you, Judge. At this time, staff calls Mark Kiesling to the stand.
Mr. Kiesling, would you raise your right hand? Thank you. Do you swear or affirm that the testimony you give today in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good afternoon, Mr. Kiesling.
Good afternoon.
Could you please state and spell your name for the record?
Yeah, it's Mark Kiesling, Kiesling.
And Mr. Kiesling, by whom are you employed and in what capacity?
I'm employed by the Missouri Public Service Commission as a senior regular research and data analyst.
And are you the same Mark Kiesling who caused a sponsor in this proceeding, the rebuttal testimony of Mark Kiesling, which has been pre-marked as Staff Exhibit 101?
Yes.
And are you also the same Mark Kiesling who contributed to the staff memorandum in response to the stipulation, which has been pre-marked as Staff Exhibit 105?
Yes.
If I asked you the same questions within Exhibits 101 and 105, would your answers be the same or substantively similar to those therein?
Yes.
And then also, are the statements made by you within Exhibits 101 and 105 true and correct to the best of your knowledge and belief?
Yes.
And at this time, do you have any corrections to make to either Exhibit 101 or your contributions to Exhibit 105?
No.
Thank you, Mr. Kiesling. At this time, Judge, staff moves to enter Exhibit 101, the rebuttal of Mark Kiesling, onto the record.
Any objections? All right, Exhibit 101 is admitted.
Thank you, Judge. And at this time, staff now tenders Mr. Kiesling for cross-examination.
Mr. Kleiser.
No questions. Thank you, Your Honor.
Mr. Briscar.
Yes, Your Honor. Good afternoon, Mr. Kiesling. How are you?
Good. How are you?
Good. My name is Joseph Briscar. I represent Nucor in this matter. You have a copy of your testimony in front of you?
Yes, I do.
Okay, I'm going to ask you a couple questions about that. If you'll start on page 5 of your testimony.
Okay.
Lines 9 through 11, you say, unless Evergy or EMW can avoid additional capacity purchases or reduces the amount of new generation needed to serve Evergy customers, non-Nucor ratepayers will not benefit from Nucor participation in business demand response in 2026. Is that accurate? That I read it accurately?
Yeah.
And first, as we know, the 2026 deadline has passed to put a new customer into the demand response program. Is that right?
To put a new customer in the demand response program? There is no deadline on that.
Or, I mean, were you here earlier for the testimony this morning?
Yes.
And there was discussion about how there was a May 15 deadline to enroll a customer for the summer period in 2026. Did you hear that?
Yes.
All I'm getting at is that their 2026 reference is likely reference to 2027 now. Is that right? Or either way, it would work either way.
It could be at the time testimony was written, it was before May 15th.
Right. And I assume you were here just now when I was cross-examining Mr. Tevy?
Yes.
And he suggested that either you or Mr. Hull might be an appropriate witness to ask about the benefits of demand response and the business demand response program?
Yes.
Are you able to talk about that?
Yeah, the benefits?
Yes. You recognize that demand response generally can provide benefits that include avoided capacity, right?
Potentially, yes.
But it can also provide reliability benefits too?
Potentially, yes.
Like if curtailing during when the system is stressed can help avoid blackouts or brownouts, is that right?
Potentially.
And so there are other benefits, aside from the capacity benefits, like we just established, the potential benefit of reliability. If a customer reduces load during the system peak, it can help reduce the system peak, is that right?
That's the design of the program.
But that benefit, the reduction of the peak and the reliability benefits, are different benefits than avoided capacity benefits, aren't they?
Yeah, the avoided capacity is supposed to be a benefit by having a BDR program, that the company is deferring future generation because of the BDR program.
Right. And if Nucor were to participate in the business demand response program, customers could see some of those other benefits as well, right?
Possibly, but Evergy didn't.
I'm sorry?
I said Evergy didn't demonstrate that.
When a demand response customer is curtailed, they are not only taking load off the system potentially, but if they remain curtailed, they're not adding load back to the system, right?
Yeah.
And so that, would you consider that a benefit as well, of not adding load back on during times of system stress?
I mean, it depends what's going on, the customer. There's a lot of factors that go into that.
So, yeah, let's say it's a large customer, 20 megawatts or something. Avoiding that load from going on the system during the system peak could help provide reliability benefits, is that right?
Potentially.
Okay. Nothing further, thank you.
All right, any cross by Evergy?
Yes, Your Honor. Good morning, Mr. Kiesling. My name is Michael Robinson on behalf of Evergy. I just have a few questions for you today. To begin, staff is not opposed to demand response generally, correct?
Correct.
And staff is also not opposed to Nucor participating in demand response, correct?
Correct.
And is it true that demand response can produce benefits to Evergy, Missouri West?
Potentially, yes.
And is it true that demand response can also produce benefits to Nucor?
In the form of incentives?
Sure.
That would be the benefit Nucor would get out of it, yes.
And is it true that curtailment by a large industrial customer during a peak reduction event reduces system peak load?
Should be, yes.
And you're not objecting in this case that Nucor should not curtail load, is that true?
I never wrote anything about that, no.
But you do object that Nucor should not curtail load within the MIA framework, is that true?
Yes.
Okay.
As it's currently constructed.
Your Honor, my next 6 questions implicate information that the company considers confidential. Would it be all right to go in camera?
Yes.
Thank you.
So we are now going in camera. We are no longer in camera.
All right, Mr. Kiesling, moving on. Is it true that EMW is the load responsible entity for purposes of SPP resource adequacy?
As it's currently, yes.
And is it true that additional accredited capacity reduces EMW's SPP capacity obligation?
I'm not the witness to talk about that. Mr. Jordan Hall could speak to that.
Thank you. All right, Mr. Kiesling, you've characterized Mr. Files' avoided capacity figure for 2021 and 2022 as unsubstantiated. Is that true?
Don't recall using those words. It's just a avoided cost that is currently not approved.
Would you mind reading lines 2 through 4 of page 5 of your testimony, please?
Yeah. Mr. Files claims of avoided cost by allowing Nucor's participation in BDR. There was not an approved avoided cost for Evergy's MIA Cycle 4 by the Commission, so any claims of avoidance of capacity cost benefits are unsubstantiated.
Thank you, Mr. Kiesling. And the basis for your unsubstantiated characterization is that, according to your testimony, there are no work papers and there is no commission-approved Cycle 4 avoided cost, true?
Yes.
But is it true that those figures that you've characterized as unsubstantiated were produced by ADM and Associates?
There is no EM&V for Cycle 4 right now. The contract was just recently approved, so there is no avoided cost.
What about-
ADM would have been the previous for Cycle 3.
Right, sorry, I was referring to Cycle 3.
Well, that's Cycle 3, this is Cycle 4.
But for Cycle 3, those figures that Mr. Files cited, were those produced by ADM and Associates?
Without verification, I would have to say yes.
And would ADM and Associates work have been overseen by Evergreen Economics?
That was the consultant that the state contracted with, the commission contracted with, to review the report.
Correct. And did you contact ADM to verify Mr. Files' avoided capacity figure before filing your rebuttal?
No, because it was from a previous cycle.
So you wouldn't do that because it was from a previous cycle. Do you know if neither ADM or Evergreen flagged the avoided cost methodology in the 2021 or 2022 evaluation reviews?
Without reviewing those reports again, I can't answer
Okay.
one way or the other.
And is it true that you did not independently perform any quantitative analysis of the costs or benefits of Nucor's BDR participation in this case?
We reviewed the numbers, but we didn't use an avoided cost.
Thank you, Mr. Kiesling. I have no further questions.
All right, are there any questions from the commissioners? All right, Mr. Pringle. Oh, I'm sorry, Chair Hahn.
Thank you, Judge Sire. Good afternoon, Mr. Kiesling.
Good afternoon.
In staff's opening statement, they mentioned a potential clawback provision if the savings are not materialized by the end of 2027. They mentioned that you or Mr. Tevy could talk about that. What would a clawback provision as staff's proposing look like?
I think what was intended with that is that the financial analysis would be done, and then that money would be set aside, and if there was not benefits shown, then that amount would then be trued up, so to speak, in a rate case.
And that would flow, that benefit would flow back to all customers, or however was determined in the rate case?
Correct.
Thank you.
Yep.
Mr. Pringle, do you have redirect?
Your Honor, technically, we would move to recross.
Oh, I'm sorry.
But I will have redirect, Judge.
Okay. Mr. Kleiser, sorry about that.
I don't know why I said that because I have no recross, but
Mr. keeping me in line. I appreciate that. Mr. Briscar, any recross?
No, Your Honor.
Mr. Robinson?
No, Your Honor.
All right. Mr. Prinkle? Redirect.
Thank you, Judge. Mr. Kiesling, I kind of wanted to go back to some of the questions that Nucor's counsel, Mr. Briscar, asked you earlier. Those benefits that you were being asked about, are they exclusive to the MIA Business Demand Response Program?
Yes.
But is it fair to say that those benefits could also arise from any demand response program?
No.
And then also earlier, you were talking about when the incentive costs are paid to a MIA Business Demand Response participant. How are you aware that the payments are paid upfront?
Paid up front?
Mm-hmm.
Well, they're paid out once a contract is constructed between Evergy and BDR. And then once an event is called, potentially, then it's verified, and then a payment will be made.
Okay. And then also, when did MIA Cycle 3 end?
At the end of 2024.
What aspect of the Evergy's MIA Cycle 3 program did the commission order transfer over to Cycle 4?
What was that again? I'm sorry.
Any specifics from the Cycle 3, like avoided costs? Were those ordered, transferred over to Cycle 4?
No, there was nothing ordered to be transferred from Cycle 3 to 4.
And then when it comes to the commission's EM&V contractor, Evergreen, its review of EM&V, are you aware, is that review specific to BDR participants or the program as a whole?
It just looks at the program as a whole. It doesn't go down on a granular level to individuals or individual companies.
One moment, Judge. Finally, Mr. Kiesling, is there a difference between potential benefits and realized benefits?
Yes.
Oh, sorry, I got one more question for you. What is that difference?
Well, the potential benefits in like this case, all the incentives and admin costs, all that will be borne by all the other ratepayers outside of Nucor. And so and I'm sorry, I forgot the other term you used, the
realized benefits.
Realized. So that additional cost will offset anything potentially that could be realized.
Thank you very much for your time, Mr. Kiesling. No further questions from staff, Judge. Simply ask that Mr. Kiesling be excused.
All right. Mr. Kiesling, you may be excused. You can call your next witness.
One more batch of musical chairs, Judge.
Mr. Graham.
Yes, staff calls Mr. Hall.
All right. Mr. Hull, will you raise your right hand, please? Do you swear or affirm that the testimony you give today in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Hall, would you state your full name, please?
Jordan Hull, Jordan, last name Hull, Hull.
Jordan, whom are you employed by and in what capacity?
The Missouri Public Service Commission as an associate engineer in the Energy Resources Division.
And Mr. Hall, have you prepared testimony in this case?
Yes.
And is that testimony, to your knowledge, marked as Exhibit 100?
Yes.
And is that Sir rebuttal testimony?
It's a rebuttal.
Oh, I'm sorry, rebuttal. And in addition, did you did you participate in the preparation of what's now been denominated or designated as Exhibit Number 105, which was testimony in the form of a memorandum that was attached and in support of the suggestions that staff filed last week in response to the non-unanimous stipulation?
Yes.
It was a long way of identifying
very
something,
long.
wasn't it? Yes. And were there two exhibits that were referred to within that exhibit, namely 104, and I'm sorry, 103 and 104?
Yes.
Okay. Now, with respect to all of those exhibits, with respect to your role in them and in preparing them, are there any mistakes or changes that you need to make?
Not that I'm aware of.
And if the questions or the information that you elicited there, if questions were put to you with respect to that information, would you provide the same information, or would your answers otherwise be the same?
Yes, they'd be closely the same.
And to the best of your knowledge and belief, were all of those answers and that information that you provided, to the extent that it required truthfulness and accuracy, were they truthful and accurate?
Yes.
Okay. I'm going to offer at this time, I believe, all three witnesses who sponsored exhibit number 105 have now testified with respect to that exhibit here. So at this time, I'm going to offer exhibit 100, 103, 104, and 105.
Any objections?
Judge, no objections, although we would renew our request correspondingly to admit Exhibit 7, which is the Bryan file testimony in support of the non-unanimous stipulation and agreement.
All right, so let's revisit that. Is there any objection now to Exhibit 7?
Yes, John Kleiser from OPC. I'm going to maintain my written filed objection to Exhibit 7.
And that is,
Or if necessary, formally make the same objection at this time, however you want to take it.
that is can you identify that document that it's attached to? Is it, it's basically the objection to the non-unanimous stipulation agreement, correct?
No, there
Oh,
were
I'm sorry.
two documents filed in EFIS on May 21st by the OPC. One was the objection to the non-unanimous stipulation and agreement, and the other was a response to motion for leave, objection, or in the alternative, motion to suspend the procedural schedule. I don't know off the top of my head what the EFIS numbers are, but I can get that to you later. The objection is lodged exclusively in the second document. The objection to the stipulation is, of course, an objection to the stipulation from a procedural standpoint, but not to its admittance.
Right, and it looks like that's EFIS item number 43. All right, I'm going to overrule that objection. And exhibits 100, 103, 104, and 105 are admitted.
And Judge, thank you. Is Exhibit 7 admitted?
Yes, exhibit 7 is also admitted.
Thank you so much.
Staff tenders the witness.
All right, Mr. Kleiser.
Thank you. Good afternoon, Mr. Hall.
Good afternoon.
Were you here earlier when I had a conversation with Evergy witness Meitner and then later with Evergy witness File regarding resource adequacy
Yes, in general.
And after I had that conversation, Mr. File had a redirect question that I feel like introduced potentially some confusion. So I want to do a quick follow-up with you, and it's going to be the same line of questioning that I've already gone through. However,
Judge, I'm sorry, I am going to interpose an objection here. This cross-examination is again against a party whose interests have been adopted entirely by OPC, and the purpose of the questioning is to perpetuate testimony that is favorable to both OPC and staff. It's not true cross-examination. Other parties don't have an opportunity to do this. Evergy and Nucor have not done it. And it's not fair, and I don't think it should continue, and I would object.
may I respond?
Yes.
First of all, it's not a basis for an actual objection. The entire purpose of cross-examination is to develop my case, which I am entitled to do. Second, I want to mention that we are not on the same page as staff. I filed a separate objection to the stipulation agreement, and staff previously alluded to the fact that it believed that it could actually get behind the stipulation if certain changes were made, which is not a position shared by the OPC. Second, I am not asking to perpetuate testimony that's already in the record. I'm attempting to address a concern that rose directly because of cross-examination of two Evergy witnesses that was further redeveloped on redirect examination. And third, I'd like to throw out, actually I think that's fourth, I'd like to throw out that the general notion of whether or not we can actually have a separate alternative that would allow for resource adequacy is an issue that this commission should genuinely want to have answered per the course of this entire case. And I will also throw out that the idea that they weren't available to staff counsel, they were available to staff counsel. Nucor had every opportunity to friendly cross Evergy's witnesses. They did not avail themselves to that. And and Evergy, for that matter, have further cross-examination after this, so they can test whatever I have to say to Mr. Hall. The entire purpose of ordering cross-examination in this manner is to allow for that exact situation.
Quick response, Judge. The OPC, like every other party, has an opportunity to redirect its own witnesses should those witnesses get questions on cross or from the bench, and that would be the venue for Mr. Kleiser's questions, not friendly cross with staff.
All right, I'm going to overrule your objection.
Mr. File's response in the redirect, he referred to the MBDR. I do not want to discuss the MBDR, so I'm going to try and pose the same question to you that I have posed previously. Is there anything preventing Evergy from putting a tariff forward right now that would allow a customer like Nucor to participate in SPP demand response programs outside of MIA that would still allow for them to be included for resource adequacy purposes in Evergy's workbooks, excluding the MBDR?
No, they can participate in those programs, and they can count it towards resource adequacy.
I'm sorry, I didn't hear the words.
They can count it towards resource adequacy.
To be clear for the record, your first part of that answer was no, they can
There's
participate.
nothing excluding them.
Thank you very much. I have no further questions.
Right. Mr. Briscar, any cross
Yes,
by
Judge,
Nucor?
very briefly. Good afternoon, Mr. Hull. How are you?
Good afternoon, I'm good.
My name is Joseph Briscar. I represent Nucor in this matter. Do you have a copy of your testimony in front of you?
Yes.
Let me see. On pages 8 and 9, generally, and throughout your testimony, you discuss the SPP verification process for demand response, right?
Yep.
And the SPP programs are governed by the SPP tariffs and market rules, right?
Correct.
And those governing documents are approved by FERC?
Yes.
And FERC regulates SPP?
Correct.
And the business demand response rules are governed by the Evergy tariff and program rules, right?
Yes.
And this commission regulates Evergy's tariffs?
Yes.
And the commission approved the currently effective Evergy tariff and MIA program rules, correct?
Yes, but Nucor wasn't in that.
I'm just asking if the commission approved the current rules.
They approved Cycle 4.
And the tariff language and the rules under the program?
Yes.
No further questions, thank you.
Ms. Whipple?
Thank you, Judge. Mr. Hull, in your rebuttal testimony, you testified that Nucor previously participated in EMW's Business Demand Response Program from April 1, 2021 through March 31, 2023, correct?
I think that was the MIA prudence review period.
All right, and Judge, I have, I think just one question, but I need to use confidential information. If we could go in camera.
All right, let's go in camera. All right, we are in. All right, we are no longer in camera.
Those historical curtailments, the numbers we discussed in camera, those delivered load reductions to EMW's system, correct?
I mean, they weren't supposed to be in that program at all at that time period. They weren't allowed to.
That's not the question I asked you, is it? Should I ask it again?
Sure.
Okay. Those historical curtailments delivered load reductions to EMW's system, correct?
That's what your data request said.
Okay. And do you have any reason to believe that's not correct?
No?
Thank you. In your rebuttal testimony, you discussed what you called pathways, essentially non-MIA alternatives for Nucor to participate in demand response. Is that right?
Yes.
Your first proposed alternative to MIA would be for Nucor to participate directly in SPP's wholesale demand response market as a block demand response resource. Is that right?
That is one option, yes.
Under the SPP demand response construct, payments are made to the registered market participant, which could be a utility, a retail provider, or an aggregator, right?
Correct.
The end-use customer, like Nucor, is then compensated through a private contractual arrangement with that market participant. Is that right?
Yes, so Evergy would be the market participant in that.
Unless the market participant is, for example, an aggregator, correct?
Correct.
Whether SPP credits a demand response resource toward Evergy's resource adequacy obligation depends on whether it is registered as the load responsible entity, correct?
Can you restate that?
Sure, I'll just say it this way.
That wasn't a question, that's why I asked.
EMW is the load responsible entity for purposes of SPP resource adequacy, correct?
Yeah.
And so if SPP is going to credit a demand response resource toward Evergy's resource adequacy obligation, then Evergy has to be the registered market participant for that, correct?
The LRE, yes.
Okay. And so we talked about aggregators of retail customers and ARC. That's one of the other pathways that you testified about in your rebuttal testimony, correct?
It's a way, yes.
You're not aware of any specific ARC contract today between Nucor and a third-party aggregator, correct?
Not that I'm aware of.
Isn't it true that ARCs participate in SPP's energy and ancillary services market?
Yes, but you can still get credit for it if you participate through Evergy, for resource adequacy.
You used the pronoun you a couple of times in there. I don't know what you're referring to.
Evergy,
Okay.
EMW, if you'd prefer.
Maybe I'll just clarify your response by asking my question. ARCs can participate in SPP's energy and ancillary services markets, correct?
Yeah, but they don't get, Evergy would not get credit for that in the resource adequacy, if that's where you're going.
Correct. Yes, thank you for that. And there's no capacity market in SPP, right?
Not currently, but I'm glad you asked that.
Are you aware that there are...
Hold on. Can I finish my
The witness
answer?
is not done with his answer.
Right.
Oh, you already answered my question.
Not to his satisfaction. I object.
I'm sorry, who's speaking, please?
Paul Graham, Staff Attorney Paul Graham. The witness is entitled to answer the question to his satisfaction, not the lawyer's.
Well, he did answer the question, Your Honor. If you know, you would like to perpetuate additional testimony on that, Mr. Graham, you can do it on redirect.
I agree.
Okay, thank you.
So,
Your Honor, John Kleiser,
yes.
I actually think the only answer we got was, I'm glad you asked that.
No, he said, I agree, and I'm glad you asked that question.
I apologize. I thought I only heard the second half.
Are you aware that there are no third-party ARCs providing resource adequacy credit to Evergy today?
I think we already said that ARCs couldn't provide resource adequacy to Evergy.
So the answer to my question is yes,
To which question?
that there are no third-party ARCs providing resource adequacy credit to Evergy today.
I don't know the answer to that.
Well, if you believe that ARCs cannot provide resource adequacy credit to Evergy, then would it follow that that's not currently happening today either?
Objection
Bravo.
argumentative.
I'll overrule that objection.
Can you ask it again?
You testified previously that you don't believe ARCs can provide resource adequacy credit to Evergy, correct?
Correct.
And so would it follow that resource adequacy is not being credited to Evergy today by any third-party ARCs?
I've not seen any contract saying that.
The third proposed alternative you have for Nucor to participate in SPP demand response is through EMW's existing schedule MBDR, which is the market-based demand response tariff, right?
Yes.
And you testified in your rebuttal testimony that there are no current participants in that MBDR tariff, correct?
As far as I know, yes.
And you're aware that the MBDR tariff by its own terms is available to existing BDR participants, correct?
Correct, but I think it could be amended just like the SIL tariff.
The purpose of the MBDR tariff is to enable a participating customer who's already a BDR participant to also engage in SPP's ancillary services and energy market activity, correct?
Can you restate that?
The purpose of the MBDR tariff is to enable a participating customer who is also already a BDR participant to engage in SPP's ancillary services and energy market.
I think that's one.
And isn't it true that in general, customers are prohibited from participating in both an ARC and EMW's BDR program for double counting concerns?
I think that's a legal question.
Do you know the answer to it?
It says in there.
Objection. He's indicated that he's not competent to answer the question. It's a legal question in his mind.
It is, first of all, not a legal question. Even if he thought it was a legal question, I'm simply asking if he knows the answer to it.
You can answer the question whether or not you know.
It does mention both of them in that, if that's your question.
Do you know if customers are prohibited from participating in an ARC and EMW's BDR program at the same time?
Objection calls for a legal question.
I don't know that it does. I think you can answer. I'll overrule that objection. You
Of
can
an
answer the
ARC
question.
in BDR?
Yes.
I have no idea.
Okay. If the commission prohibits Nucor from participating in the MIA BDR program, that would also mean that Nucor cannot participate in the MBDR existing tariff, right?
Your Honor, I'm going to object. What I hear here is counsel writing her brief through this witness's mouth with legal arguments laced with facts, argument, inference, conclusion. She's just writing a brief here, and it's a completely argumentative line of question.
Your Honor, this witness has been proffered as an expert in tariffs and non-MIA alternatives, and I am asking about what's in his testimony and the permutations of that. If he can't testify that because it's a legal conclusion, then I'd like that to be on the record about his testimony.
All right. I'm going to overrule that objection. You can answer the question.
Can you repeat the question for me?
If the commission denies Nucor's BDR participation, then it follows that under the MBDR tariff's existing terms, Nucor couldn't participate in that either, right?
Not currently, but I already said it can be amended just like the SIL tariff's going to have to be.
That's what your opinion is, correct?
That's what you're asking.
Yeah, that's not tariffs today. It's just your opinion
Well,
that
the
it could
tariffs
just
today
be
say that you
changed.
can't even be participating.
That's right. Yes. You also testify that SPP Block Demand Response Resource Program and EMW's BDR program apply different reporting and verification standards. You testify about that, right?
That is correct.
Isn't it true that the more stringent baseline telemetry and settlement requirements that you talk about with regard to SPP in the SPP Open Access Transmission Tariff are applying to market-registered demand response participating in the energy and ancillary services market?
Yes, but they're also opening that up to, that's what I was trying to get to earlier before. So there's actually tariff language for, SPP proposes to a credit capacity for demand response resources, and they can count towards the amount of capacity. That was a proposal that SPP had on April 17th of 2026. So as of right now, I think it's energy and ancillary services, but it's opening up. And I think that's the pathway that they're moving.
And that's
based
not,
on-
those changes are not in place at this
No,
time.
but it's in tariff language from last month.
And the MIA BDR program is not registered as a market participant in the energy and ancillary services market of SPP today, correct?
No.
The purpose of the MIA BDR program is to deliver resource adequacy value to EMW as the load responsible entity, correct?
Yeah, but you could do that through SPP too.
That's your opinion, right?
That's what their tariff says. I've not
Whose
seen
tariff?
anything in SPP's tariff saying that you could not participate.
There's just I'm trying to understand, you were talking about a future tariff that's not in effect, and are you now talking about the currently in effect SPP open access transmission tariff?
Yeah.
Okay. So let me just make sure that I understand what you're saying.
Okay.
Under the current SPP open access transmission tariff, the MIA BDR program offered by EMW is not registered as a market participant in SPP's energy and ancillary services market.
That's correct.
Okay, thank you. Now, when you're talking about the non-MIA alternatives in your rebuttal testimony. Isn't it true that you testified that they still require this commission to approve an amendment to Nucor's SIL contract before Nucor could participate or pursue any of them?
Yeah, I have language in my rebuttal.
And isn't it also true that you have not independently verified that the alternative pathways would in fact deliver SPP resource adequacy value to EMW as the load responsible entity?
Can you restate that?
Isn't it true that you have not independently verified, in that you haven't contacted SPP, for instance, that any of the proposed alternative pathways would deliver resource adequacy value to EMW as the load responsible entity today?
I've
Correct.
listened to working groups on the in SPP, and I haven't seen a reason why they couldn't.
Are you the correct witness to ask questions about staff's clawback condition proposed in the staff memorandum filed in response to the non-unanimous stipulation and agreement?
No.
Who would that witness be?
I think that would be Justin Tevy.
Okay. Are you aware, I'll just ask you, are you aware if that proposed clawback condition is referring to clawing back MIA participation costs and routing them through the SIL tariff's hold harmless provision?
I'm not sure.
Okay. Do you know all of the requirements of SPP for participating in their block demand response, dispatchable demand response tariffs?
I read the tariff.
Do you know if the requirements are the same or different from the requirements to participate in the MIA BDR program?
They're different. They have more guardrails.
Do you know that whether SPP in fact verifies resource adequacy value in the MIA BDR program?
If SPP, say that again?
If SPP is going to credit EMW against its resource adequacy obligation because of the MIA BDR program, you're aware that SPP verifies that?
Yeah, but they couldn't credit them the same as if they were in the demand response program because there's different baselines.
They're different, but SPP verifies the resource adequacy obligation credit that EMW would receive because of participation in the MIA BDR program, right?
I believe so.
Okay. No further questions.
All right. Chair Hahn, you have questions?
Yes. Good afternoon, Mr. Hull.
Good afternoon.
I feel like we need some clarification here, so I'm going to make some statements, and I want to ask if you agree. At SPP, market register demand response, or DR, cannot be used for resource adequacy currently. It can only be claimed as a load reduction from the LRE, or load responsible entity's peak demand forecast.
That's false. They can get credit for resource adequacy right now
Under what program?
under SPP's tariff.
I don't believe that's the case, but they could in the future under revision request 703 on the formal framework for DR and LRE peak demand assessments, correct? Which is currently being.
Capacity. Are you talking capacity?
Capacity.
Yeah, I'm talking resource adequacy. You can get resource adequacy credit, accreditation, but you can't get capacity credit until they decide what to do with this proposal.
My understanding from SPP is that the reduction is taken into account in the net peak demand, which is used as the load forecast benchmark for ensuring compliance with the resource adequacy requirement.
Can you say that again? That was a lot of words.
Of course. Currently, demand response for resource adequacy purposes can only be claimed as a load reduction against the load responsible entities, LRE's, peak demand forecast. This reduction is taken into account in the net peak demand, which is used as the load forecast benchmark for ensuring compliance with the resource adequacy requirement. Revision request 703.
Yes.
Okay.
I agree with that.
Okay.
We have a data request from Evergy saying that they can use it in the resource adequacy workbooks. That would be DR20. Do you want me to read it?
That would be helpful.
Per our discussion with SPP, Evergy as the LRE can utilize Evergy market registered DR programs in our resource adequacy workbooks. To reduce our net peak demand, Evergy does not currently have any market registered program for block demand response or dispatchable demand response.
I think that's in line with what I'm saying.
Okay.
that's
Maybe I was
accurate.
misunderstanding you.
Okay. So they can't count it actually toward capacity for resource adequacy purposes until FERC litigates revision request 703.
Correct.
Okay.
I think that's where we were.
Yeah. Okay,
Okay.
we got it.
Yeah.
Thank you.
Do any other commissioners have questions? All right. I have kind of just kind of a general question. Staff has filed their objection to this non-stipulation or non-unanimous stipulation and agreement, but are there any provisions in that stip and agreement that staff could support?
I think there were certain ones. I would have to read it again.
Do you need a second to look at it?
I would say me personally, no, but staff might have different opinions. I think the SPP's program is putting up the guardrails that need to be in place to have successful demand response that's actually competitive and shows actually what that capacity is worth.
In Witness Meitner's rebuttal, in response to your rebuttal, he stated that the other demand response programs that staff has suggested as alternatives for Nucor do not provide adequate provide resource adequacy benefits. Should demand response activities provide resource adequacy benefits?
I think in SPP they have to,
Okay.
because there's no capacity market.
Okay. All right, Mr. Kleiser, do you have recross?
First, you referenced DR20. Is that attached to your testimony in any way?
I think so. I do not know off the top of my head.
Because it was referenced and read in, I would move that it be admitted as an exhibit, and I'll offer it as an OPC exhibit if necessary. That's more for the completeness of the record than anything. If it is already attached, then obviously I don't need it.
Mr. Graham, do you know if that's attached?
I can look real fast.
Help me again with what it is. I tried to understand what you were referring to, but
Staff data request 20 answer.
I do not know. Let's see what he said.
I don't think it is actually. It might be in the memo.
Company has no objection to admitting it as an exhibit. and don't care whose exhibit it is.
Again, I'm really just more for the completeness of the record. I'll offer it as OPC Exhibit 202 and get a copy in. It's staff DR, sorry, it's the response to staff DR 20.
All right, do any other parties have any objection to that coming into evidence? All right, then Exhibit 202, correct? 202?
I have 202.
Okay, is admitted.
Boy, I don't know if I want to ask any further questions on the conversation you had with the chair, because I think I'm going to confuse myself, but I'm going to do just one to see if I can. Do you agree with what Judge Sayer read regarding the surrebuttal testimony offered against your position on the resource adequacy? That the alternatives you recommended do not offer resource adequacy?
I think they do. You can offer it, and they've said they can use it in their workbook.
All right. I have no further recross. Thank you.
All right, Mr. Briscard?
No questions.
All right. Ms. Whipple?
None, thank you.
All right. Mr. Graham, any redirect?
No.
All right. Mr. Hull, thank you for your testimony.
Thank you.
Yeah, that's fine.
Let's take a break at this point and reconvene at 2:30. Let's go back on the record.
Thank you, sir.
All right, at this time, the commission would like to recall J.P. Meitner to the stand. Mr. Meitner, you're already under oath, so if you could just take a seat. Chair Hahn.
Good afternoon. I apologize for doing this, but I think a lot of confusion was potentially created. So I think there's some part of your rebuttal that can be helpful.
Okay.
So I just want to clear up a couple things about resource adequacy at SPP.
Sure.
Okay. When we say resource adequacy used in your workbook, it means different things. It can mean accredited capacity. It could mean a calculation as far as your peak demand forecast. It could mean a few different things. In your rebuttal, you say that your Evergy's current programs do not allow you to reduce the company's net peak demand. Is that still your?
The point I'm trying to make is when looking at the tariffs, the Evergy tariffs available today, the only tariff that allows for resource adequacy treatment is MIA BDR.
Okay. And MIA BDR is the only one, as far as capacity accreditation, that you get credit for in resource adequacy at SPP.
Correct, and the demand response portion would be taken against the peak load forecast.
Thank you.
All right. Do any of the parties have follow-up questions? And I'll begin with Nucor.
No, Your Honor.
All right, staff?
No, Your Honor.
Public counsel?
I'm sorry, I didn't get this response.
I haven't supplied one yet. I apologize. That was someone speaking. Yeah, so very briefly, John Kleiser on behalf of OPC. Your testimony is that right now the only existing tariff is Evergy's MIA BDR program. That's what you've testified to, correct? Oh, sorry. Let me clarify that. You've testified the only tariff available to meet the resource adequacy through SPP for the demand response program is Evergy's MIA BDR program. Is that right?
The MIA BDR program would be the only avenue to supply the demand response towards Evergy Missouri West's resource adequacy process via the net load or the load forecast.
Does Evergy, for purposes of meeting resource adequacy, is SPP look at Evergy West as a standalone or combined with Evergy Metro?
Evergy Missouri West is a load responsible entity. As far as the resource adequacy process, SPP views it as a combined entity.
And would you agree with me that right now, Evergy as a combined entity meets its resource adequacy requirement today?
For the summer of 2026, it was sufficient or cured of any deficiencies.
So a short answer would be yes.
For the summer of 2026 is what I was clarifying. The answer would be yes.
And then again, my last question really, well, I shouldn't say that. It's never the last. Could Evergy create a tariff that would allow?
I'm going to object. This is beyond the scope of Chair Hahn's question. She asked what resource
I'm
adequacy.
sorry, who's objecting, please?
This is Roger Steiner with Evergy. This goes beyond the scope of Chair Hahn's questions. She didn't ask about future tariffs. She asked about what the existing tariff said.
Did she? I thought that her question generally was trying to get clarification as to the testimony provided in his rebuttal.
The questions were directed to Evergy's current process.
As far as the questions relate to the testimony in his rebuttal, let me ask a question then directed to the language in his rebuttal. Would that be sufficient?
That's also beyond her questions. She had one question. We're already up to 5 follow-ups.
Since when does the number of questions matter?
When it's
I'm
3
gonna
o'clock in
overrule
the
the
afternoon.
objection.
I will try and keep this short. At page 3 of your rebuttal testimony, beginning at line 1, it reads, Evergy does not currently have any market-registered programs for block demand response or dispatchable demand response programs. Do you see that in your testimony?
I don't have my testimony with me.
I apologize. Would parties object if I handed him my copy?
Go ahead, Your Honor. Go ahead, John.
I can go back and get a copy. I didn't realize. Okay.
It's fine.
Okay.
I'm just looking at that language in that bracket. It's beginning at the sentence beginning on line 1, continuing to line 2. I can't repeat it because I don't have it in front of me now, but is it hopefully consistent with what I just read?
Yeah. Yes, it says, you want me to read it?
Go ahead.
Evergy does not currently have any market-registered programs for block demand response or dispatchable demand response.
You would agree with me that Evergy could create programs?
Again, this is beyond the scope of Chair Hahn's questions.
I'm going to overrule that. You can answer the question.
This question was asked to me earlier, and I deferred it to witness file. I'm not the expert on the Evergy tariffs.
All right, thank you. I have no further question. I would ask for that back, though. Thank you.
Okay. Any questions by Evergy?
No, Your Honor.
All right.
That's Roger Steiner.
All right. Thank you. And I believe we are to the point where we are going to have testimony from the public counsel's witnesses. Is that correct? Mr. Kleiser, is that correct?
That's to my recollection.
Okay. Call your first witness.
All right, the OPC would call Mansell Payne.
Mr. Payne, you've got your right hand raised. Thank you. Do you swear or affirm that the testimony you give today in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Mr. Payne, can you please state and spell your name for the record?
Yes. Mansell Payne, Manzell. Last name is Payne.
And have you prepared or caused to be prepared testimony which has been pre-marked Exhibit 200, the surrebuttal testimony of Mansell Payne, public and confidential?
Yes.
Do you have any corrections you need to make to that testimony?
I actually do, yes. Very briefly.
Can you please explain those questions and identify the page number on which they would have, sorry, those corrections and identify the page number on which they would occur?
Yes, page 1 of my surrebuttal. Question 21, what is the purpose of your direct testimony? That should be surrebuttal testimony. Page 2, line 10, Mr. Hull's testimony elaborates on why Nucor's special rate it actually should, there's, the word "y" should not be there. Should be crossed out. And then my last one, sorry for so many of these. Line 4, participating in the MIA BDR program with, also taking, should be while instead of with.
I'm sorry, what was the page number on that last correction?
Oh, page 5, sorry.
Page 5, lines 4.
Yes.
Thank you. And with those corrections, would your answers today be the same or substantially similar to what you gave in your pre-filed testimony?
Yes.
And are your answers true and correct to the best of your knowledge and belief?
Yes.
This time I would offer as OPC Exhibit 200, the surrebuttal testimony of Manziel Payne, public and confidential versions, and tender the witness for cross-examination.
Any objection to that testimony coming into evidence? All right, Exhibit 200 is admitted.
I have tendered the witness for cross-examination, Your Honor.
I understand. Mr. Graham?
No questions.
Any cross on behalf of Evergy, Missouri West?
Yes, Your Honor. Hi, Manziel. My name is Mike. I just have a few questions for you today. To begin, you did not sponsor any independent quantitative analysis of the costs or benefits of Nucor's BDR participation in this case, true?
I did not.
Okay. And you also did not perform an independent SPP resource adequacy analysis for EMW, true?
I did not.
And you also did not independently audit the work papers underlying Mr. Files' avoided capacity figure, correct?
No.
And you've testified that you agree with the positions that staff has taken in this case, is that true?
Yes. Up until their new position of sponsoring portions of your guys' stipulation.
But beyond that, yes?
I believe so, yes.
Okay, thank you. And are you aware that staff has also not performed an independent SPP resource adequacy analysis for EMW?
I am not sure what staff has done on that front.
But do you know if staff has, in fact, performed an independent SPP resource adequacy analysis for EMW?
I do not know.
Okay. What about, do you know if staff has performed an independent quantitative analysis of the costs or benefits of Nucor's BDR participation?
No, not off the top of my head, but I feel like that is on Evergy. I feel like that is Evergy's burden of proof.
Thank you. Mr. Payne, to be clear, you're not against demand response programs in general, is that true?
That is true.
Nor are you against Nucor's participation in demand response programs generally, is that true?
I believe I might have mentioned that I'm not against that. I think it's just the current MIA structure.
But you don't object to Nucor curtailing load in general?
I don't think so, no.
Isn't MIA at present the only commission-approved way for EMW to get resource adequacy?
I actually do not believe that I am the correct witness for that question. I think Dr. Mark would be a better person to ask that question.
All right, Mr. Payne, you have not quantified the SPP resource adequacy value that Nucor's megawatts of accredited curtailment would deliver to EMW as a load responsible entity, correct?
Can you restate that question?
Sure. So the SPP resource adequacy value that Nucor's megawatts of accredited curtailment would deliver to EMW, you have not quantified, calculated, or otherwise verified that value, have you?
I have not, but on that front of resource adequacy, I would strongly encourage you to ask Dr. Mark about that.
Okay, thank you. Now, you recommend that the commission deny EMW's application, is that true?
Yes, as it stood at the time.
And your fallback recommendation is that Nucor be directed to a non-MIA pathway, correct?
Yes.
And those non-MIA pathways that you reference are the SPP demand response options in Mr. Hull's rebuttal. Is that true?
Yes, and I believe Dr. Mark also expands on those, and I would recommend you asking him those questions as well.
So just to be clear, then you have not independently analyzed whether any of those pathways would in fact deliver resource adequacy value to EMW. True?
That is true.
Okay, no further questions, thank you.
All right, Mr. Briskar,
No questions, Your Honor.
are there any questions from the commissioners? All right. Any redirect?
I guess just very briefly, you were asked a large series of questions regarding performing independent analysis just now. Do you recall that?
Yes.
Did your testimony rely on the analysis performed by staff or Evergy with regard to the benefits?
No, it does not.
I have no further redirects.
All right. Thank you for your testimony. You're excused. All right, Dr. Mark is the next witness. Would you raise your right hand? Thank you. Do you swear or affirm that the testimony you give in this hearing shall be the truth, the whole truth, and nothing but the truth?
I do.
Thank you.
Good afternoon, Dr. Mark. Can you please state and spell your name for the record?
It's Jeff, Geoff, Mark, Marke.
And by whom are you employed and in what capacity?
By the Missouri Office of Public Counsel as the chief economist.
And have you prepared or caused to be prepared pre-filed testimony which has been marked as OPC Exhibit 201, surrebuttal testimony of Jeff Mark?
Yes.
Do you have any corrections to make, or would you like to make to that testimony?
No corrections.
If I were to ask you the same questions posed that testimony today, would your answers be the same or substantially similar?
The same.
And are those answers true and correct to the best of your knowledge and belief?
Yes.
Your Honor, I will move for the admission of OPC Exhibit 201, surrebuttal testimony of Jeff Mark.
All right, any objection? Exhibit 201 is admitted.
Your Honor, I tender this witness for cross-examination.
Mr. Pringle?
Yes, thank you, Judge. This is Travis Pringle on behalf of staff. Good afternoon, Dr. Mark.
Good afternoon.
Now, was the OPC a signatory to the non-unanimous stipulation agreement resolving the Evergy's MIA Cycle 4?
We were.
And are you aware of the company's position that the commission implicitly approved the avoided cost within its application?
I'm familiar with the company's argument.
As a signatory to the stipulation, is it OPC's understanding that those avoided costs were implicitly approved?
No.
Why not?
Those avoided costs were an issue of contention during the MIA case. What are we avoiding? You know, was ultimately, you know, at heart of the MIA case. In that MIA iteration, we actually had to combine Metro and West together to go ahead and effectively do the mental gymnastics. And the commission will recall, Evergy never went to hearing over its MIA. That was a settlement that happened outside of, basically, post-Ameren going to hearing. But a lot of the arguments that were present in the Ameren case were just as present in the Evergy case, or even more pronounced, because for reasons that have already been addressed, there is no capacity market in SPP. Parties, including OPC, came to an agreement moving forward, but OPC and the parties never explicitly articulated what the avoided cost assumption is, because again, that avoided cost assumption was really just at issue in terms of how you could calculate it. And
Judge, I'm sorry, I'm going to have to object. This violates the commission's pre-filed testimony rule. You know, staff's question relates to the company's position as filed. OPC had an opportunity on rebuttal and surrebuttal to offer pre-filed testimony as to the avoided capacity costs from Cycle 3 and that implicitly being carried over to Cycle 4. And so this testimony is just being manufactured on the stand today, and it should have been offered in pre-filed testimony months and months ago.
May I respond? My understanding is that this was brought up in the surrebuttal testimony of Brian File, which there was no chance to respond to that. So seeing as how this is cross-examination and I am building staff's case, this is a completely fair question.
And Your Honor, it wasn't. This has been the company's position since their application, and I actually think, Travis, I mean, we don't have a live feedback here, but I think that was your question. It really has been since the company's application.
Well, given the testimony that was offered with the non-unanimous stipulation agreement, I'm going to overrule that objection and allow the question.
Thank you, Judge. And forget where you were at, Dr. Mark.
Well, Mr. Pringle, we're not avoiding anything. I mean, that's really at the heart of it. We're not avoiding anything. And the CCNs that we've got in front of the commission are evidence of that. You know, context is important for OPC and why we were signatory to that in part was because we spent a good decade filing memos, filing testimony, effectively saying that Evergy West ratepayers were exposed to the market for a number of years. We overpaid in fuel costs. We overpaid in a number of different areas because Evergy West elected to go ahead and strand one of its coal plants. Now, what's changed between now and when that MIA was approved is, I mean, heaven and earth has changed. We weren't talking about data centers during that first MIA. We weren't talking about the amount of generation that the company is building moving forward here. So when we sit here where the company is trying to shoehorn an avoided cost estimate that's 4-5 years old, that was premised on shaky data at best, and trying to put that as a forward proxy for what we're actually avoiding it doesn't reflect reality.
Thank you for that, Dr. Mark. And also just a few questions for you about resource adequacy. It is your understanding that at least for the company's SPP resource adequacy accreditation for summer 2026, Nucor can't help that at this time, correct?
There are no benefits for ratepayers if the commission approves this today. Zero. We're effectively saying, here's $1.25 million that we're going to go ahead and section off to the company in Nucor.
And you're saying that's not even just this summer, but also next summer there'd be no benefit?
Well, next summer, the numbers will change again. We will have to adjust for all of the generation that we have brought on and that we are building moving forward, because you got to keep in mind, it's not Evergy West here that we're talking about, it's Evergy. So it's all of Evergy combined that is part of that resource adequacy. And Evergy is long. As a holding company, as an entire entity, they are long on capacity. So we get the accredited resource adequacy from deferring future load for Nucor. It's not moving the needle one way or the other. And then again, the big X factor that we have moving forward is we just don't know what the world is going to look like with these data centers.
Thank you for your time, Dr. Mark. I have no further questions.
All right, Cross on behalf of Evergy.
Not at this time, thank you. Judge, maybe this isn't the time to raise it, but we would request to be able to put Brian File back on the stand to respond to the testimony of Dr. Mark regarding the capacity 3 avoided capacity costs and his understanding as a Cycle 4 stipulation signator, which was new testimony just now, and so the company could respond to it.
I'll allow that.
And when would you like that to happen? I don't want to throw a wrench in it, but we could do it after Dr. Mark has completed all of his testimony and all of the questions, or whenever Your Honor would like.
That would be my preference.
Okay, that'd be great. Thank you.
Are all these questions regarding the terms of a stipulation that isn't in the record?
Is that a question for me, or is that a question for Ms. Whipple?
Honestly, it's an open question at this point. I mean, should we put the cycle 4 stipulation in the record at this stage if we're gonna have multiple questions related to how to interpret it?
If Your Honor is eliciting responses from the parties on that, I don't think that's necessary. The testimony that we just received for the first time today from Dr. Mark was his perception of whether the Cycle 3 avoided capacity costs were implicitly brought forward in the Cycle 4 order approving the Cycle 4 stipulation. That's the only question, and he gave a lot of testimony on that. It's not about the stipulation itself.
I would also put forward, Judge, that I think it'd be perfectly fine with the commission just simply take judicial notice of the report and order approving that stipulation and agreement.
Right, I agree with you, Mr. Pringle. I'm sorry.
Thank you, Judge.
All right, and so the commission will take judicial notice of that report and order. Mr. Briscar, do you have any cross?
Just a couple. Good afternoon, Dr. Mark.
Good afternoon, Mr. Riskar?
Briscar, yes.
Brisk.
Yes, Briscar, yes. I represent Nucor in this matter, as I'm sure you're aware at this point. Do you have a copy of your testimony in front of you?
I do.
Okay. I have a couple questions, or just a handful of questions about your testimony, but I wanted to follow up on a response that you gave to staff just now. In response to a question, you stated that if Nucor, I'm paraphrasing here, but if Nucor were allowed to participate in the business demand response program in 2026, it would provide no benefits in 2026. Is that correct?
Yes.
But the stipulation in this case provides for participation starting in 2027. Is that correct?
I don't know what you've stipulated with the company over.
You have not reviewed the stipulation?
Cursory.
Okay, fair enough. If you'll refer to your testimony at page 8. Beginning at line 10, you have a question and answer about basically data centers and their impact going forward. Are there any data centers on the SIL tariff?
No.
Do you agree that data center loads could be very different than steel mill loads?
Sure.
And that data center loads generally have a pretty high load factor. They run close to all the time.
Generally, data center loads are going to be more flat.
Right. And as we've heard today, the steel mill loads can go up and down. And considering the data center's load, do you agree that their ability and willingness to participate in demand response may be very different than that of a steel mill?
I can't speak for the data centers.
Fair enough. Thank you. That's all.
All right, are there any questions from the commissioners? All right. Mr. Kleiser, redirect.
I guess just very briefly, with regard to the questions you received regarding the difference between data centers and a steel smelter, maybe I misunderstood. What is the significance of the data center that you are bringing up?
Today, or really past tense, at this point, when we contemplated Nucor, Nucor was a special snowflake in its overall size. Moving forward, that distinction is being eroded as you bring on large data centers and large customers. So the impact an individual that Nucor will have by default is going to diminish as a result of that. The last Q&A effectively in my testimony that Nucor referenced was just largely just a call more for the commission that, hey, there's a lot of things in flux. SPP is changing their rules literally as we speak. And as the data centers materialize, there needs to be a larger conversation about how demand response works.
Thank you. You, as part of your response to staff questions, you made the statement, Evergy is long on capacity. For the sake of the record, can you please explain what you mean by long on capacity?
So the company is required to meet a certain megawatt threshold. It is constantly changing. It's usually, like a 10, 15, 20% more than what their actual peak demand is. So the company invests or has invested, with all sorts of resources to exceed that level. And that's been the case. When SPP looks and values Evergy as a standalone entity, they're looking at all the generation that's in place. And for their part, like Evergy is as well. Evergy's not sitting there saying, hey, it's a peak demand time right now. We're going to go ahead and focus in on calling our demand response customers, because Evergy has assets that they need to run to make money. Okay, like that is the key component right there. And that's why demand response, unlike in the MISO footprint, runs into a number of challenges on the SPP footprint. The value for ratepayers is severely diminished because of the vertically integrated nature of SPP.
Thank you for that response, but to be clear, for the sake of the record, literally what does the word long mean?
They have more generation than they will be able to utilize.
Thank you very much. And do you happen to know numerically what that looks like?
I looked at the winter and summer SPP resource adequacy reports. The summer has the company long over 100 megawatts.
Would you happen to know whether or
I'm
not
sorry,
the numbers?
I'm sorry, I missed some of the words. The summer has the company long, continue.
Well, no, 1 second. Would that information be confidential?
No.
Okay, please continue. I apologize.
So I had an opportunity to do, to effectively look at the resource adequacy numbers that have been filed with SPP in the summer. It's north of 100. That's just the Evergy Missouri. If you throw in the Evergy Kansas with it, it's well over 1,000. The winter was over 1,000.
And you throw out numbers without units, 1,000 what?
Megawatts, sorry, or 8 gig, so.
Thank you very much. I have no further cross-examination.
All right.
I mean, stand corrected, it's 800 in the winter, not 1,000. It's still much more than what the load is for Nucor.
Okay, thank you. I have no further redirect.
All right. Thank you, Dr. Mark. And you have no further witnesses, correct?
So, is the commission recalling Mr. File?
My position is that she can recall him as a rebuttal witness if she would like to.
I would just like to point out, it would appear that we're trying to develop competing testimony over the different parties' understanding of the implications of a report and order. Why would we need testimony evidence for how different parties are interpreting a commission's report and order?
I'd also be happy to strike Dr. Mark's testimony in that regard from the record and not recall Mr. File.
I would also like to point out, Judge, that the company did not redirect Mr. File on this topic, so I believe they've actually lost their chance to do this.
We couldn't.
Be a second bite at the apple,
Dr.
seeing as
Mark-
how on cross-examination.
I'm sorry, overspeak.
That was Mr. Pringle.
Yes.
Yeah.
It was more having to do with on cross-examination, Mr. File was directly asked about the implicit approval, and there were no further questions from the company on it. Seeing as how OPC was a signatory to that same agreement, not quite sure why they didn't ask Dr. Mark about it themselves. They did not.
Mr. File or Dr. Mark? The chronology is that Dr. Mark testified after Mr. File did this day.
But no, actually the chronology is Mr. File was questioned about it, and then on redirect, the company did not follow up with him on it.
Dr. Mark never testified about this in his pre-filed testimony. He just took the stand and offered testimony that was never previously offered in this case. That violates the pre-filed testimony rule.
And again, I'm looking at the surrebuttal testimony of Mr. File. If the company can point out where in his direct testimony he talked about the implicit approval, I'm not finding it.
good news. I think that we are going to withdraw the request to have Mr. File take the stand, and it has to do with my misunderstanding of Mr. File's testimony, and I understand now, and I'm comfortable with the record as is. And thank you all for indulging me.
Okay.
However, to be clear, the commission is taking administrative notice or judicial notice, whatever the proper phrase is, of the report and order that we're all attempting to interpret.
Yes.
Thank you.
And for the record, that number is EO 2023-0369 and 0370.
Could you give those last four numbers?
Yes. 0369, I believe, was the Evergy Metro, and 0370 was Evergy West. But they were both settled together.
All right. I have not seen anything in the filings that indicated that expedited transcripts were requested. So I would expect the transcripts to be filed within 10 business days or so of today's hearing. And then per the procedural schedule, the initial briefs are due June 18th and the reply briefs are due July 2nd.
Do we have a minute, Your Honor?
Yes,
Who's speaking, please?
that was,
An unknown voice. Roger Steiner, Evergy.
Judge, if it's all right with you, in light of the transcripts coming out in 10 days, the parties have agreed, again, if it's all right with you, to change the briefing schedule.
how so?
If we could please move the initial brief deadline, it's currently July 17. I'm sorry, June 17. If we could please move it to, I think it's June 18. So is it the 18th?
We want to change.
But we want to change it to June 25th.
Okay.
And then the reply brief deadline, I do not have that in front of me when it is, but we'd like to change it to July 9th.
July 2nd. So initial briefs would be due on June 25th rather than June 18th, and reply briefs would be due July 9th rather than July 2nd. And all parties are in agreement, correct? Yes. Okay. All right, if there's nothing further, is there anything further? Let me ask you that.
Just a little house cleaning on staff's part just to make sure we got our exhibits
I'm
in.
sorry, who's speaking, please?
This is Travis Pringle on behalf of staff.
100 to 105.
Yes, I believe we have a public and confidential 100, a public and confidential 101, a public and confidential 102, and then a 103, 104, 105.
Right, all of those exhibits were previously admitted into evidence.
Thank you, Judge.
John Kleiser for OPC. Is the bench going to take, or will the commission take all the pre-filed exhibits without us submitting copies?
Correct.
Thank you.
All right. So with that, I'll adjourn the hearing. We'll go off the record.
Thank you, Judge.
Am I able to ask for transcript orders?